In fact, we have raised an objection. Now they have accepted it. No, we have no objection. The delete, not pressing the prayers, my lord.
Senior Advocate Mr. Ashok Preja, on request, on instructions of his the counsel on record appearing for the representing the petitioner, gives up the prayers B and C of amended petition. First up, from the other side to such giving up. First up, in the above circumstances, the petitioner to amend, strike off the said two prayers.
Grateful minutes.
Prayers at earliest. After request?
Well, reopening immediately after.
Yeah.
We are reopening.
My lord, 25, 26,
Second.
29, my lord.
29th is a little late. Then my lords want to.
Court reopens on 22nd, na?
Yes.
20, so we'll have this matter.
Lord, 24th, 2 p.m. your lordship is.
Let us see.
Lord,
We can't give.
I have it on 29th, my lord. 29th.
Just to mention.
I want to come physically, my lord. I want to come physically and argue the matter, my lord. So, lordship, I have it on Monday, the 29th.
29th, you are coming. We'll have it on 29th.
Fair enough.
Yeah, I'll come physically.
All this matter on 29th.
29th.
Grateful.
At 2 p.m., my lord, it will be very nice. If it is 2 p.m., nothing.
Yes. This day fixed with consent of fixed consensually. Okay.
Item 2.
There was one High Court which treated validity of similar regulations.
I'll check.
Just looking.
Yes.
Yes.
Item 2. Occupancy 35142 of 2025.
Agree, sir.
Yes.
I'll just hand over the amendment.
This has come on as a special assignment.
As a special assignment, not because the Honorable Chief Justice was not inclined to.
Yes.
No. Your Lordship well knows, my Lord, under List 1, Entry 54, it is the central government which regulates major minerals.
It is the Parliament which does major minerals.
Major minerals. In exercise of those powers, my Lord, the central government, my Lord, amended the MMDR Act, my Lord. Lordship will see
The
the
government amended or Parliament?
Parliament amended. Brought about a bill. It was
Because
amended.
we are very particular.
Lord,
Students.
I'm obliged for
Yes.
it. I'm obliged for it. Lordship will just take the amended act. I've given the amended act. Kindly turn to page 10. At the foot of the page is the pagination, my Lord.
Page 10.
My Lord.
Yes. Yes.
No.
Can we see it from page 9?
My Lord, Lordship will be.
8A.
My Lord.
You are challenging
I'm
evidence against
obliged. I'm
8A.
obliged. I'm obliged. 8A, my Lord. Period of grant of a mining lease for minerals other than coal, lignite, and atomic minerals. The provisions of this act shall apply to minerals other than specified in Part A and Part B of the first schedule, my Lord.
Correct.
I am a Part C mineral, my Lord.
Not Part A.
Part A, not Part B. So I'm a Part C.
Part C mineral is what?
Is chromite. Chromite.
Chromite.
On and from the date, subsection 2, my Lord.
Commencement of.
On and from the date of commencement of the Mines and Minerals Development and Regulation Amendment Act, all mining leases shall be granted for the period of 50 years.
Correct.
My Lord. And if your Lordship takes the 5th schedule at page 44, they said for 50 years plus, you have to pay an additional amount of the royalty at the rate of 150%.
This is the 5th schedule to the rule.
To the
Act.
to the act.
To the act.
To the act.
The provision which you have read, is it act or rule?
It is the act.
Act only.
Act.
Okay.
So therefore, if a mine is renewed 50 years plus, the company which is the lessee is to pay 150% of the royalty in addition to the royalty.
Extra royalties.
Yes, extra royalty, that's the precise word. This, my lord, was imposed upon all the companies. Now what happened was, we are purchaser of chromite minerals, chromite ore from the Orissa Mining Corporation, which is a nodal agency of the state of Orissa.
You are purchaser.
Purchaser.
You are not a miner.
No, I'm not a miner. I have a separate mine that doesn't concern your lordship. There are two
A
methods.
buyer of goods.
Of goods. Now there are two methods by which I can purchase it. One, via a long-term lease agreement, which is called a long-term linkage agreement. The second is auction purchase. There are two methods.
Lease agreement.
Long-term linkage agreement between me and the Orissa Mining Corporation. Because we have our plant in Orissa for which...
Saying they will supply mines for 15, 20 years. Like this, such agreement.
Milord. It's a long-term agreement where the price is variable depending on various conditions. No problem with that. Now, when this amendment was brought into effect, my lordship gets it on page 10 at the foot of the page on 28/3/2021. Now, the Orissa Mining Corporation started adding this 150% to the sale price in order to pass on the burden to the final purchaser.
Yes.
No problem with that. Now, what happened? Your lordship will take, my lord, the brief for a moment. What happened thereafter? One of the central PSUs, my lord, raised this issue with the state of Orissa as well as the central government, saying that my mine doesn't exceed 50 years. So is this 150% loyalty? Am I liable to pay it?
Who is liable to pay? Subject to duration of the lease.
Absolutely, ma'am. Absolutely. So one of the central government
undertakings, not that all leases will attract that levy.
I will put it to you this way, my lord. If it is up to 50, no additional. If it is
above 50,
additional comes in. Now kindly take page 160 of your lordship's brief annexure 8.
But this is royalties payable by whom?
By the lessee, by the Orissa Mining Corporation.
Mining Corporation. From whom you buy it.
Absolutely.
How you are concerned with this?
Well, they pass on the additional royalty. They pass on the additional royalty back to me.
It's a question of sale of goods act.
Well, I'll come to that. Kindly see the clarification of the central government. I'm conscious of the sale of goods act. Well, kindly take 160 annexure 8. The relevant, my lord, starts at 161. 160 talks about additional payment of royalty for such and such mining lease of NALCO, which is a central public sector.
No.
Kindly turn over to 161, paragraph number 5.
Therefore,
the extension orders issued by the state government are not extension orders in terms of Rules 72 and 73 of the Mineral Concession Rules 2016. Rather, the extension orders are issued under 72(1) of the Mineral Concession Rules, which is erstwhile Rule 3(1) of the Mineral Mining by Government Rules 2015, recording that the leases have been deemed to have been granted for 50 years. It is further informed that in case of private non-PSU mines as well, the benefit of deemed lease period of 50 years have been provided without the payment of any additional amount. Hence, it would not be correct to impose additional amount on government companies for any order passed by whatever name, allowing them deemed lease period for 50 years. Therefore, this ministry has rightly concluded that the additional amount as specified in the 5th schedule will be payable only when mining leases are extended beyond 50 years, that is such and such case respectively. Further, the additional royalty paid by NALCO so far in respect of these two mining leases may be adjusted in future royalty payments. Next page, 162. This is on a clarification sought for by the state. The Ministry of Mines communicates to the state, starts at 162. The relevant your lordship will get at 167. Top of the page. Therefore, the additional amount as specified in the 5th schedule will be payable only on those mining leases which are extended beyond 50 years in such and such case. paragraph 19, it is further informed that in the case of private non-PSU mines, the benefit of deemed lease period of 50 years has been provided in the Act without the payment of any additional amount. Hence, it would not be correct to impose the additional amount on the government companies for any order passed allowing them deemed lease period of 50 years. In view of the above, the answer to the query of the state government as to whether the additional payment will be made on completion of 50 years of validity of the lease of the government company in absence of such explicit mention under the provisions of the 2016 rules would be affirmative. Further, it is once again requested that the additional amount already paid by NALCO so far in respect of these two mining leases may be adjusted against royalty payments. Now, I'll just take the next page, which is the direction from the government to the Director of Mines. Just the last paragraph. The Ministry of Mines, Government of India have clarified in the said letter that the additional amounts so received may be adjusted against future payments of royalty and other statutory dues in view of the above, as approved by the state government. You are allowed
Not to charge additional amount.
not charge and adjust it against future.
Whatever is paid. That
Whatever is paid. I'm deeply obliged. What happened with OMC is at page 172. Now they have got the refund from the state government already. It is at just 172. I have obtained it under RTI. Kindly see.
it is adjusted.
Adjusted. All I'm
It is received.
received. And they are now holding it back. Two other writ applications have been filed wherein this Honorable Court has already been pleased to issue notice. All I'm praying for is for your lordships to kindly issue notice for the state government and
Similar matters.
Similar matters.
You could have said it as first said.
But my attempt was to persuade your lordship and then
Learned senior advocate appearing for the petitioner,
Aditya Das.
appears that similar matters have already been are being entertained by coordinate benches of this court in WPC 35098 of 2025 between Ferro Alloys Corporation Limited versus Orissa Mining Corporation Limited and WPC.
And WPC 35331 of 2025. Le Babu.
And WPC 35331 of
2025
between Orissa Steel Limited versus State of Odisha. First, come on, and therefore, on parity basis, notice in this matter also be issued. First of, we agree. Issue notice. Learned DSG, Mr. Paddy, is requested to accept notice for
OP1.
we appear, says so and so. Accepts notice for OP number 1, Union Government, and Mr. Panda or G, who will accept in mining matter. Learned DSG
2, 5, 6, and 7.
accepts notice for 2, 5, 6, and 7. Emergent notice to
3 and 4.
3 and 4. First up. Only this matter is before this bench. Rest of the matters are the other bench.
I'm obliged to. They can be tagged fully for that.
Call this matter after vacation.
Along with those two matters, your lordship.
Okay, then.
Very good. Very good.
The chief prerogative.
I'm deeply.
Item 3, WPC 12722 2026.
One aspect, of course, so just we are putting you on caveat. Like doctrine of privity of contract in contract jurisprudence.
Look,
There is privity of statute, which Australian High Court Judge, Justice Michael Kirby treated. Look into that. There has to be privity between yourself and the law also. Suppose law contemplates X with whom you have some dealing, then you cannot take that view is available. Just exam.
May I please, Lordship? Item 3, kindly pass over.
Read.
Thank you.
What it is, Max? We'll start secret formula. Yes. Brother, we have a small request. Why you are using the word beg? It's your right to argue, right to tell the judge to do like this. We may not do. That's another.
I could not remain present when the matter
If
was
you want to
taken.
beg, go to some temple. Not here. You are all partners, equal partners. It is only by conspiracy of circumstances. Happily you are placed there. Maybe unhappily we are placed here. We don't know. But on par with each other.
I do agree.
Yes.
Well, the petitioners before violates Miller because after settlement of the account under the one-time settlement and deposit of the entire amount, the bank is not returning the land documents.
Is it true?
The instruction is different. Bank is supplying copy the rent.
Yes, sir, I'm supplying.
Issue heard. Learned counsel appearing for the petitioner. First up. Grievance is short that despite discharge of the loan obligation, the security documents are not being returned to the borrower. Sri, so that senior panel counsel on request accepts notice for all of this. Copy numbers 1 and 2.
Yes, for
Emergent notice to 3 and 4. Call immediately after vacation since matter lies in a very narrow compass.
public.
They can supply them.
Yes, yes, I'm supplying it for plan.
Item 4, WBC 12933 of 2026.
Yes.
Lord, this writ application is directed against the order passed by the Central Administrative Tribunal.
Pardon, my lord. Pardon to interrupt, my lord, please. I'm the opposite party. I'm appearing for the opposite party. Having been instructed to appear, I'll file Vakalatnama. But some defects are there that having been not removed, the matter should not be taken at the administration stage also.
Let us see.
Why, before my learned senior addresses, I'm well aware of the fact that he has a right to begin being the petitioner, so also a designated senior counsel. My lord, this is the standing order of this Hon'Ble Court before filing of this application. The registry should have pointed out that there are defects. So these defects having been not complied with, this matter cannot be taken as admission.
In the noting, there is nothing.
It's a matter between court and the state. It's not you.
No, your lordship kind of, because it is a standing order of this Hon'Ble Court.
If your lordship should see the cause list, no defect has been mentioned.
I'm aware of that.
Then,
But in terms of this order,
my lords,
are you aware of this order?
no,
Because your client has not given to you.
Client comes and okay, senior comes and the comes. No, the opinion, sir.
Yes. Whether you have produced entire pleadings and the documents that were before the trial,
I don't think so because
then you comply.
I'll do that, my lord. That I have
Let
absolutely
it come
no
after
problem.
vacation, let him
Please
talk.
do not talk. Who are you? We have not issued notice to you.
Okay, man.
Are you heavy hitter?
No, man.
Sit down. Sit down.
Sorry,
You
man.
have no voice.
Sorry, man.
None.
Extremely sorry, man.
You comply.
Let's come next week. In the meantime, I'll
Immediately after compliance. Why next week?
No,
Maybe urgency also, we don't know.
no. He is in service, so no urgency. Only the pay scale and the increment has been stopped. So on compliance, your lordships can say.
Registry to look into aspect of compliance in terms of standing order number 3 of 2025. And if compliance is done, matter to be posted before the appropriate court.
Can I pray a service of copy, my lord, since I have taken caveat?
Have you filed caveat?
Yes, my lord.
Then give copy also.
I'll
After necessary correction,
caveat was on the by the client on his address, so it has been sent there. I'll give him after compliance. No, it will be after compliance only. Then I can give him the complete set.
yes.
That I
That's what I prayed.
Why did you then answer when Lordship asked you whether you were in caveat? You did not.
You said no. All wrong instruction. Clear.
Item 5, WPC 14284-2026.
Yes. The petitioner has taken loan for 9,60,000 for agricultural purpose, poultry farming. 9,60,000.
964,000.
60,000.
60,000.
9,60,000.
When?
In 2022. 9/3/2022.
How much you have paid back?
1 year he has paid my lord.
What is the
Cyclone due to
Is it EMI?
Yes, ma'am.
Monthly?
It was EMI.
1 year you have paid.
1 year.
Is it true?
I am not instruction, but instruction is it has turned NPR 9/9/2024. Thereafter, bank has taken 13-2 notice and 13-4 notice. Ultimately, the property has been taken permission to possession. So that's why he has come the challenging the sale. So my submission before Lordship is the alternative remedy is there. If he is challenging the entire surface action, then DRT is openly.
You want money.
And then you Lordship, I agree.
Or you want property?
No.
If your bank officers want property, we have other remedy.
No, Miller.
You have lent money.
I fully agree.
Beyond getting money, you have no other interest.
Miller, that is true. That is probably money is to
When are you going to make money?
Actually, his financial condition is
Very bad. Then
Yes,
let
my
them
lord.
sell the property.
Installment, if it will be regularized, again he will pay an EMI.
For that, you have to make a representation.
Miller, the regulation stage is over.
It is over.
Because now we are in position and it is NPA 2024. We are now in 2026. And he did not, though he has said to pay, but he didn't pay.
Now, if he pays, will you accept?
Definitely, if he pays the entire amount, definitely bank will.
He will pay it within 1 month.
Entire amount?
Entire amount.
Entire amount within 1 month. That is,
that we can do. Even if you go to DRT, nothing will happen there. Because we have been seeing so many cases. Only being heard, adjourned, no relief to the litigants like that. So you say that you are an agriculturist, and agriculture is held to be a lifeline of this country by apex court, 2 judgments. Therefore, some indulgence we want to show, provided you bring the money.
it is 11 lakhs. No,
11 lakh 25,000, maybe 30,000.
No, Miller, now it is 14 lakh 69,000.
For whatever. It is a matter of arithmetic calculation.
Miller.
All right. You pay it within 3 months. They will wait for 3 months.
So last installment is at least.
That will. Prima facie, first installment, you have to show bona fide by making.
5 lakhs or more.
How finance? 3 months.
In 3 months he may pay, but for bona fideness within 1 month, he should pay something. At least I will take instruction from. Tell them
that. Even if you go for auction, this, that, etc.
That definitely, because we want money, but it should be also fair. Otherwise, value of money is there, Miller.
The essential grievance of the petitioner, moreover, is against the coercive action of recovery. We'll give 4 months. He's an agriculturist. Apex Court said agriculture is lifeline of this country. Therefore, those of that occupation should be protected. Otherwise, it will be empty. Much shadow signifying nothing, to borrow the words of Shakespeare.
Because your lordship, sir, because I cannot take, because I cannot also suggest.
Presently, a sum of rupees 14 lakh.
14 lakh 69,349. 14 lakh 69,000.
14 lakh 70,000 is stated to be due in all. First term. Learned counsel appearing for the petitioner submits that money was borrowed for agricultural purpose and that the agriculturists in this country are not that better placed regard being had to a host of factors, both natural and man-made. First, therefore, he further submits that reprieve be granted so that he would amass the required amount and remit the same to the discharge of the loan outstanding if a reasonable period is accorded. First, next one. Learned panel counsel appearing for the bank vehemently opposed the petition, contending that the petitioner is not a petitioner, though an agriculturist, not scrupulous borrower, and that he has not adhered to the terms of loan agreement. Semicolon. Now the matter having traveled to the stage of section 13(4) of the Surface Act 2002, even the possession of the property is
to be taken, but DM possession, DM's order has been released.
14 also.
14 also.
14 or 6? Yes, no. 14.
6 and 14.
The stage of 14. Interference of this court is not warranted. First, next, having heard learned counsel for the parties and having perused the petition papers, we are of a considered opinion to grant reprieve to the petitioner, opinion that the petitioner needs to be granted reprieve in extraordinary jurisdiction of this court for the following reasons. 1. The apex court in the case of researchers, so and so has observed that the agriculture is the lifeline of this country. Semicolon. Professor Swaminathan, in his report on agriculture and allied avocations, has suggested that agriculturists as a class suffer from the wrath of nature and also man-made acts, and therefore some protective provision needs to be put into policy. First off, be that as it may, learned counsel for the petitioner very fairly submits that if a period of 4 months is granted, his client could repay the entire loan amount with interest accruing due thereon in terms of the agreement. First up. Next paragraph. This is absolutely fair. First up. Next paragraph. It hardly needs to be stated that even when time is granted or extended for payment of the repayment of the loan, no prejudice should be caused to the lender in as much as the borrowed money would carry the interest at the agreed rate, which the borrower would remit. First one. A writ court cannot deny relief to a worthy litigant by quoting some jurisprudential theories. Semicolon. Quote the first one. Justice Oliver Wendell Holmes in Thames versus so and so has observed as a next paragraph. In the above circumstances, this petition is disposed of with the following directions. Number 1, the petitioner shall repay the entire amount, loan amount within an outer limit of 4 months reckoned from this date. Number 2, the petitioner, in order to take benefit of this discretionary order, shall remit So 4 months? Whatever above. In 4 equalized installments, equalized monthly installments. Number 2, the petitioner shall be entitled to take the benefit of this discretionary order only if the first installment is paid on or before 10th of June 2026. And thereafter to pay other installments scrupulously within the period as prescribed. Next paragraph. If the petitioner fails to make the payment as ordained here, the bank shall be entitled to take physical possession of the property with the aid of jurisdictional police, and that the petitioner shall yield the possession peaceably to the bank for further process. No cost. Next.
Item 6, WPC 14435/2026.
May I read your words?
Yes, sir.
My lord, here the petitioner challenged the order passed by the Law Tribunal under Annex 12, that is the impugned order. It is page number 48, my lord.
What was your grievance before the tribunal?
That in OA, I filed one OA in OA number
Why?
110. The reason, my lord, petitioner challenged the inquiry conducted by the OP2. OP2 is the disciplinary authority.
Who are you?
I am working as a officer superintendent in railway.
Superintendent in railways.
Railways. OP2 is the disciplinary authority. The disciplinary authority conducted the inquiry against me.
What was the charge?
Charge at
Draft case.
One draft case.
3,000 rupees. CVIS.
Draft case.
One of
For the
our
process of the staff's files for benefit.
one of our employee.
Money, but
3,000 rupees.
That CBI case is pending. That is no doubt. My lord.
Just we want to know.
My lord. My lord.
We should know what man, when a man stands before us,
My lord.
we have to scan him.
My lord.
Therefore, we are asking the question. Well, how many years of service he has put in?
How much was?
All right. How many promotions he has done?
Till date, my lord.
Yes.
Promotion.
These are essentials of disciplinary proceedings, law relating to punishment.
That is
How
joined
many
in
years?
superintendent, post of superintendent.
Post of superintendent.
They are joined in post of superintendent.
Post of
Some other posts are
Other one
promoted
got promoted.
because
No, he's joined office superintendent, my lord.
no promotions.
No, if they are not.
promotional post.
his superintendent is a promotional post. He must have joined the lawyer to that.
So he earned one promotion.
First, my lord. First he joined as Group D post, then he's
What you do?
my lord.
Rama Joyce, in his famous book Services Under the State, and Samaraditya Paul in Law Relating to Public Service. There are 2 famous books available in our library, court library. Separate 2 chapters are dedicated for disciplinary proceedings. What all to be argued, what all to be considered. You read today, now go there. You come next week, so that it will help you instead of dismissing it on your poor performance. The client may suffer. You don't want to read.
I want to read, my lord.
Read
I
and
need to
come.
read.
Call next week to enable counsel for the petitioner to equip himself more and come back. Yes.
Item 7, WC 14541 of 2026.
Next week.
Next week with some urgency. Yeah. See, one request we make you. When we go to a war field, we should have complete knowledge of what our enemy is. What is the terrain? When it rains, what is the highest temperature? What is the lowest temperature? Availability of the food, the facility for carrying the weapons, the availability of medical service, and other catastrophes. Unless you know that, how are you going to enter the warfield? Similarly, when you come here, you should know what is the law on the point, which are the best books on this, what the great authors have said. What are the best judgments on this? You should prepare that way. Then you come. That will help you. Otherwise, it will not. Suppose you do not read Cattle Trespass Act at all, and you never know how the cattle behave. How are you going to argue the Cattle Trespass Act? Is it? Therefore, come equipped. That will give you an advantage. Very good book I am suggesting, because many youngsters are sitting here. There is a famous book, Learning the Law, by Professor Glanville Williams, who edited the 10th edition of Salmon's Jurisprudence. One of the great scholars. Read and come back. But don't waste time. You will be wasting your time, our time. Yes.
Item 7, WPC 11541 approved.
May I please, Your Lordship? My Lord, I am challenging the opposition notice dated 11/3/2026 under Annexure 3.
Possession notice. What is the loan amount?
My Lord, what has happened was back.
What is the loan amount?
My Lord, 82 lakh.
82 lakh rupees. As what is this amount taken for?
My Lord, for business purpose.
For business loan, commercial loan. When it was taken?
My Lord, 10/4/2014.
What was the EMI?
1,05,645.
1,05,645.
645.
5,640. How many EMIs you have paid?
My Lord, from 2014 till 2020, I have paid regularly.
How much money totally?
Total, my Lord, 40 lakhs, my Lord.
2014 to 2020.
Yes, my Lord.
14 to 2020. 16 into 12. 16, 160, 192. Then you have not paid for so many years.
Because of Corona, I could not pay, my Lord.
No, even middle you have not paid.
My Lord, in the year 2021, I paid rupees 41 lakhs from, I took a loan from Reliance Commercial Finance, my Lord. In the year 21, I paid 41 lakh in order for settlement, my Lord. Then what happened, my Lord? In 2022, Reliance Commercial Finance was took over by opposite parties, my Lord.
Loan was taken over by another lender.
Now, my Lord, I am ready and willing to pay, my Lord.
What is the position now?
My Lord, it was the property is in my possession.
In your possession.
Yes, my Lord.
14 order is made now?
No, 13/4 only I got.
13/4.
13/4 is
13/4.
possession notice.
Within what period you will be paying back?
My Lord, it's an amount of 80 lakhs. So I need some time, my Lord.
Some time means tomorrow.
83 lakhs, 59,306.
So around 84 lakhs. It is.
Agent.
If you pay him, they will be very happy to do.
My Lord, I'll pay. I am ready and willing to pay, my Lord. I just need some time. Or else, my Lord, if this court permits, I'll go for a one-time settlement and let them consider.
You need our permission. There are RBI guidelines. You make representation, they will consider.
Let them consider, my Lord.
All right.
My Lord.
Petitioner borrower is grieving against the coercive action of recovery constituted under the provisions of Surface Act 2020. First off. Learned counsel having argued the matter for some time vociferously now submits, and we agree that his client should make an appropriate representation offering to avail OTS facility in terms of extant RBI guidelines. Learned panel counsel appearing for the bank, although opposed the petition, now agrees that if an offer is made, there would be no difficulty for treating the same in accordance with the RBI guidelines. Extent. First, in view of the above, writ petition is disposed of with above observations. First, to facilitate making up of OTS offer, bank is requested not to precipitate matter for a period of 2 weeks. For 2 weeks, don't precipitate. In the meanwhile, the bank shall take the action on the representation in contemplation, on the offer in contemplation, keeping in view the RBI guidelines. Till that happens, no precipitatory action shall be taken. To show bona fide how much you will pay along with your representation. It cannot be a free application. You are not buying a train ticket.
My lord, 5 lakhs, I think.
10 lakhs you pay. It is made clear that the application for OTS shall be accompanied by a bank draft of rupees 10 lakh to show the bona fide.
My submission is 25%. Normally, along with the OTH, it comes with.
Then you tell them, you deposit so much amount, and other things, this one. This is again subject to the extent of banking policies. Okay. They structure that properly. Yes.
Within
2 weeks he should do, and the application should be
disposed of within another week.
We leave it to you. You can take 1 year, but till then you cannot take coercive action. Till the application is considered and the result of consideration is informed to the petitioner, no coercive action shall be taken.
Fails to approach within 2 weeks, we are free to take action.
Within 2 weeks you will make.
If we fail to do that,
if you do, you are entitled.
That will be observed.
Not yes. Next.
Deeply obliged.
Item 8, WBC 14859 of 2026.
May I please, Your Lordship?
Yes.
It's a particular case where my father died in the year 2005, Your Lordship. The property is mortgaged in the year 2019 by some trusters, and section 13.2 and 13.4 notice has been issued.
When the loan was taken?
The loan, Your Lordship, 2019.
Correct. Give the date.
Your Lordship, that is, the date is, first date is 13/1/8/2019.
13/8/2019.
Yes.
How much money?
Your Lordship, 17 lakhs. 17 lakhs 94,442.
About 18 lakhs.
About 18 lakhs.
Then purpose of loan?
Purpose of loan for business, Your Lordship. For running a institute.
What was the EMI?
EMI, I don't know. Reason being, Your Lordship, I am not known anything, Your Lordship.
You should go to bank and ask them.
Lordship, kind of visualize the situation. 2005, my father died.
2005?
Yes, Your Lordship.
Loan was taken when?
2019. That is the only case.
Who took the loan?
A fraudster, Your Lordship. OP number 6.
How we can decide whether fraud is committed, whether he is a fraudster?
Yes, Lordship, I have given the death certificate before Your Lordship.
How death certificate?
The property, it's a factual aspect, but reason being, Your Lordship, it's the ancestral property of my father.
Ancestral property?
Yes, Your Lordship.
Now the borrower is related to your father, how?
He is one of the son's son, Your Lordship, grandson. My brother's son, Your Lordship. I residing in Jharsuguda. He put the property mortgage along with in connivance with this finance, Your Lordship.
Whether property, there was partition in the family?
No, not at all.
Then he is owner of the property along with rest of the
rest of it.
Yeah.
Joint position should have been. But what he does, he manipulated my father's signature who died in 2005, and he made him as a co-mortgager.
You filed a complaint before the police.
Yes, I have filed a complaint.
They will take action.
Against the customer. But what fact remains, Your Lordship, now the opposite party number 3 going to take over the possession of the land and building, Your Lordship. For that reason, before Your Lordship, I have.
In Hindu law, these kinds of arguments are made because you do not see Hindu law. Under your, whether in the state Mitakshara is applicable or
Mitakshara. Yes.
Best of it. In the Mitakshara Hindu law of Vijnaneshwara, Mitakshara is a commentary on Yajnavalkya. Mitakshara's commentary, that Vijnaneshwara wrote Mitakshara. He says, amongst Hindus, there is a presumption that every Hindu family is a joint Hindu family. Sometimes presumption extends to sometimes family owning the joint family. Now presumption need not be because you only say that it is ancestral property.
Lordship,
Understand?
Yes,
Then, unlike amongst Muslims, here, suppose if there is 10 acres of land, there are 4 brothers. Each brother is owner of entire 10 acres of land, not 2.5 acres of land. Every property belongs to everybody. Till shares are divided in partition. If that principle is applied, where will you stand? Therefore, Mullah on Hindu law, mains on Hindu law, Raghavachari, this standard book should be read in the High Court.
Yes,
you are not before the Munsif Court. Even before the Munsif Court, you should read and go.
Yes, bow down.
Then where do you stand? Now we are asking this question.
Lordship, kindly have a glass to annex.
No, assuming that he has defrauded.
Yes, yes.
Suppose if one of the co-owners steals the property,
yes,
Makale say there is no theft at all because he is owner of entire property. You see some judgments under section 379 of IPC.
Fact remains.
Fact remains your father did much long after, much before. Yes. Only a day after he signed your father's signature and did everything.
Yes, yes.
How we should decide?
I bow down to that. But
you go to DRT. Will permit you.
Till that day, Your Lordship.
No, will not do.
Lordship, they will take care of the house, only house of the family, Your Lordship. That is there, Your Lordship.
The mortgage happened in 2019.
19, Your Lordship.
13/8/2019.
Yes, Your Lordship.
When you came to know?
Recently,
where have you stated? How you came to know? When you came to know? A mortgage is a registered document.
No.
It's a deposit of title deeds.
Only ROR has been given.
No, that is it's also public document.
Yes, Your Lordship. I have given Your Lordship the paragraph. Only when I got this notice when I visited my village, Your Lord.
Where have you stayed?
Para 7. That the petitioner last week visited his ancestral house at village Kud, where he came across a notice issued by the Advocate Commission, namely Vishwajit Pradhan, opposite party number 3, to vacate the scheduled property for taking physical possession.
You issued notice to advocate also. A party here.
Yes, yes.
Advocate.
It's a commission, Your Lordship. Advocate Commission, he is the
commissioner.
Section 14 under he has been appointed as the Advocate Commission. And I have. And petitioner action is after going through the notice dated so and so, where it has been reflected that by order dated so and so, passed by the learned CDM A.SJ Katak in miscase number so and so in the matter of Bhartana Finance directed the opposite party to take physical possession of the scheduled property. This fact has never been came to the knowledge of the present petitioner, Your Lordship.
What is your qualification and what are you doing?
I am in Jharsuguda. I am working as.
What is your qualification?
Right now, qualification is graduation, Your Lordship.
What graduation?
In BA, Your Lordship.
BA.
Yes.
From which college?
That is, I have to
In
take.
Bhubaneswar, or because exposure we have to decide. Man is having exposure or he is only in the land, agricultural land.
That
What is your age now?
70 years, 69.
69 years.
69 years.
No. No, you are not, we cannot undertake all that. If you were to be a minor or etc. In 2019,
Yes.
you were 50-year-old.
Yes.
Huh? And family is joint.
No, they are separated. Your
Very stage. Partition has taken place.
Lordship, that is.
Where? When the partition took place? Is it after death or before death?
In specific what I have not stated the partition part, but I have stated, Your Lordship, kindly have a glass to para 5, Your Lordship. That the recorded tenant, namely late Pranakrishna Naik, expired on 14/12/2005 at the age of about 80 years. Living with his legal heirs, namely his son, namely Kulamani Naik, since deceased. Hrusikesh Naik, the present petitioner.
You are also son only.
I am Pranakrishna's son.
Huh?
Pranakrishna's son. One of these
Sons?
Recorded tenant's son.
recorded tenant.
Yes. Recorded.
Your brothers are there.
My brothers are there.
How many? What is from the original tenant? There are sons.
This land is not owner.
He is one of the sons.
No, he is not owner. This land is
No, how can it be?
tenancy.
You are not the owner. So
No, I am not the owner.
Huh?
My father is the owner.
then
Then Pranakrishna and the open number 6 is one of the son's son and 2 daughters.
How can we examine all these aspects?
I will move.
You move the DRT.
I will move the DRT, Your Lordship, till a decision is taken only for breathing space, Your Lordship. Reason being, Your Lordship, they will take over the position and it will be.
When it was issued, notice.
Notice, Your Lordship, that is 8/4/2026.
On which date we are now?
We are in. They have given 20 days time to.
Then why did you not go to DRT immediately?
I have come across lately.
That we cannot do. Law does not come to those who are sleepy and hardy.
I bow down to them. They have taken all the products, Your Lordship.
Petitioner being the grandson of
son of recorded tenant.
Son of recorded tenant.
Yes, Lordship. Annexure 1 is the R1.
Pranakrishna Naik is your father.
Yes, my father.
Borrower is one of his niece.
Grandson. My niece, Your Lordship.
Not niece. Your nephew.
Nephew, Your Lordship.
Petitioner alleging fraud and fabrication is seeking writ remedy against the coercive proceedings of loan recovery. First off, learned counsel for the petitioner submits that his client came to know of the entire episode of the loan and the recovery process only when he received a legal notice dated 8/4/2016 26 at Annexure 3 from a court commissioner discharging the order made under Section 14 of Surface Act 2002, and therefore this court should come to aid of his client, keeping in view the apex court decision in P. Changalavaraya Naidu versus Jagannath. Right. Next one. Having heard the counsel for the petitioner and having perused the petition papers, we decline indulgence in the matter in as much as the allegations of fraud and fabrication cannot be adjudged in a limited constitutional jurisdiction vested under Articles 226 and 227. First off, added, the petitioner can have remedy at the hands of, read that section 17.
17.
17. Read section 17. Any person aggrieved.
Any person.
What even? Added to this, comma, petitioner has got an alternate and more efficacious remedy as provided under section 17 of the 2002 Act, which employs the word any person aggrieved. Correct?
Yes,
Employs the term any person employed, right? And not necessarily the borrower or the like.
Yes.
First off, if allegations of the petitioner are taken at face value, comma, he answers the description of person aggrieved. First, in the above circumstances, petition is disposed of, relegating the petitioner to the statutory remedy under section 17 or such other remedy elsewhere, keeping open all contentions of the parties. First, it is also open to the petitioner to seek appropriate urgent interim relief if appropriate proceedings are instituted before the appropriate body. Okay. In that connection, I'll get let us come now. Okay. Next.
Item 9, WBC 1486 of 2026.
May I please, Your Lordship?
Yes.
Your Lordship, this is a matter wherein petitioner is challenging. Yes. The petitioners herein are challenging section 13.2 and 13.4 notice on two scores, my lords. First is there is a deviation and violation on the procedure established by the Act and rules therein. Second, my lords, by that deviation and the violation, my statutory right has been curtailed. Now, just a brief factual. This is the on two scores which I'll be placing before Your Lordship. Now, the brief factual background being that, my lords,
What is the loan?
it's a the total outstanding as on date is 91 lakh some odds, my lords.
What is that loan?
One is cash credit account, which my withdrawal limit was 30 lakhs, and they said that I have exceeded my withdrawal limit up to 89 lakhs.
Sir, commercial.
My lords, I am a rice mill. Petitioner is the guarantor. Petitioner number 2 is the rice mill, my lords. So another is an equipment purchase loan of 2 lakhs 8,000 and some odd, my lords. Totaling to 91 lakhs outstanding.
Why we should intervene?
No, Milos, because there is a point of law involved, Milos.
What is that?
Yes, Milos. Why I said that on two scores, I'll be on both the two scores is on point of law, Milos.
Yeah, so that all you can be, that can be urged before the tribunal also.
No. Why I say Milos? Your Lordship knows that it is no more res integra that Milos. Your Lordship has ample powers to entertain.
Yes, we have. But we decline to exercise.
My lords.
Our power is coextensive with the requirement.
My lords.
But the point is, you have an alternate remedy. Go before the tribunal.
Why?
Go before the tribunal.
No.
Yes.
Why?
Until he goes to the tribunal, he will not trouble him.
My lords, why? Just Your Lordship, if Your Lordship may bear with me for a moment, I will just give.
No, we'll not waste the time on all these things.
No, my lords. Why I am saying only a point of law is involved? I am before.
It can be argued before the tribunal. Whether tribunal does not have a judge.
Yes, there are some judgments that I wanted to place.
Liverpool.
No. Not with regards to maintainability. What I say that the section 13.2 notice is in sheer violation of Rule 3 of the Security Enforcement Rules.
He challenged it.
Milos, that is my only
strongest ground for you.
Milos, that apart, Milos.
But for 2 weeks, don't take any precipitate reaction.
Milos, no.
2 weeks. He has to go before the tribunal, na?
Milos, vacations are ensuing vacations. Keeping in mind the ensuing vacations, Your Lordship may.
Petitioner
only possession notice has been issued. Symbolic possession notice.
But don't precipitate it. So that we are asking.
Definitely.
We are asking. There is another good hospital. If you go there, it's a specialist hospital. He wants to go to that hospital on a bicycle.
Yes.
You cannot remove the air. Is it not? You should permit him to travel, cycle. Yes. The essential grievance of the petitioner is against the coercive action of loan recovery constituted under the provisions of 2002 Act, Surface Act 2000. First off, learned counsel for the petitioner vociferously submits that there are apparent errors of on the record, on the face of the record, and therefore his client need not be relegated to alternate statutory remedy. First off, he stresses that only 2 points of law are involved, and therefore the writ court itself should adjudge them. First off, learned panel counsel appearing for the OPs, which OP?
Sole OP, only sole OP.
Resists the petition, contending that where a statutory tribunal is constituted by act of the parliament, comma, the wisdom of such act of the parliament, comma, there is no reason for the writ court to grant interference merely on askance. First off, no extraordinary circumstance is pointed out as to why this court grant interference. First off, we agree with this submission. Next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to approach the DRT under section 17 of the 2002 Act within a period of first off, all contentions are kept open. To facilitate the availment of the alternate remedy, comma, the bank is requested not to precipitate the matter for a period of 2 weeks.
Considering the vacation, your lordship may grant me some.
What vacation? For tribunal also?
My only that is very personal, that is that I am not available for quite few days, your lordship may kindly
give it to other lawyer. Why you only should be? There are hundreds of lawyers. Yes.
Item 10, WBC
Your lordship may only reflect that my urgent interim relief may be considered, only your lordship.
Hardly needs to be stated that petitioner may seek urgent interim relief at the hands of the tribunal. If grounds do exist, there is
Item 10, WBC 1498/2026.
Yes. But in this matter, any urgency? Item 10, no?
Item 10.
Yes, pass on. Next.
Item 12, Rate Appeal 633 of 2023.
Identical issue or the last tomorrow. Yesterday, my lord, at serial number 9.
Brother G.
My lord.
This serial number 11, can we take day after tomorrow?
Yes, no problem.
Call tomorrow. Because we are in other partial matters, na?
Yes. 11.
Yes. 11. 12. Yes, 12.
Item 12, Rate Appeal 633 of 2023.
Yesterday, item 9.
That matter we disposed of, Mr. Hon'Ble pointed out that it is not in the list. I misconstrued the list as if it is posted. It is only records were placed, number 1. Number 2, it is not in our roster. It is with Honorable Justice K.R. Mahathapatra Sam. List was only here for reference. Reference it was. He pointed it.
Since it was along with the list,
this matter was disposed of under wrong impression of the court that it was posted for hearings yesterday. Come on. Disposed of. Why not a declaration? Along with the writ appeal number 355 of 20. First one. However, the matter was not posted. That matter was not posted for hearing. And therefore, we could not have disposed it off. First time. I did. The matter does not pertain to our Roshan. First time. Next paragraph.
Similar.
In the above circumstance, this the order dated so and so, whereby this appeal was disposed of, stands recalled ex dubito justitiae. First of registry to post the matter before appropriate bench.
Item 13, read appeal 1469 of 2024.
Out of a common judgment, your lordship has already in one of the writ petition, two of the writ petitions, your lordship have already passed the orders.
Have you served a copy on the other side? You should give all those things in advance. Otherwise, how they can read?
Sorry, Lord. That is page 24 of the appeal.
You change the factors here. Delay. How many days of delay?
It has been
One more ground there. Oh. The above apart, the appeal has been filed after booking a long delay of so many days, 303 days, and an application in INM so and so supported by affidavit is moved, seeking its condonation. First, a perusal of the application does not prima facie show a plausible explanation, does not prima facie offer a plausible explanation, and therefore the CD application is rejected. That was 13 and 14. 13 and
make the correction.
You have done some correction? No, I have made a correction. No.
And one more identical for the common judgment is pending, that may be taken.
That's all tomorrow. Yes.
Item 14, read appeal 2015 of 2024.
Yes, sir.
Chandra Malik. This is Krishna Chandra Malik's case, that is.
I will change the. Just change it. This photo. How many days of delay?
200.
200. How copy paste what Mr. G, where is the application? Copy paste application. He has written para 3 in the earlier order. No. That delay cannot okay. Give that change the fact. This paragraph has to be. Yeah.
Item 15, read appeal 296 of 2024.
Disposed of the matter in accordance with that. Krishna Chandra Malik's.
Krishna Chandra Malik.
That's why may not dismiss the appeal because that there will be a problem. Dispose of this.
Instead of this board. Yes.
Item 15. Item 15, read appeal 2964 of 2024.
This is work charge establishment. NMR he is. In this matter, it has taken at rest and G. Balakrishnan case.
G. Balakrishnan or Kulavani Vestra.
Pulamani Behra, G. Balakrishnan, Upadi, Supreme Court.
Kulamani Mishra.
Pulamani Mishra, G. Balakrishnan is the
G. Balakrishnan is the original one. That read petition number? This is
been disposed of in terms of Pulamani Mishra document. That is
we decided a few matters, na? Do you have that judgment?
No, that have
NMR.
in the rate petition, my lord. My lord, I'll provide the copy, my lord, pass it over.
Devavrata Mohanty. That is not WA. No, but Kulamani Mishra is referred to with a single thing. Yes, follow.
State of Odisha versus and others versus G. Balakrishnan. It was of the rate application.
Which one is that? WA?
No, that is WPC number 8102 of 2019, passed by the High Court of Orissa. Disposed upon 11/5/2022. This is specially petition civil diary number 33400 of 23.
Just write down and give. This state appeal, intercourt appeal by the state, calls in question a learned single judge's order dated 13/2/2024, whereby respondent employees WPC number 19912 of 2023 having been favored, the following relief has been accorded. Paragraph 6. Next paragraph. Appeal is moved after brooking a delay of how many days? 226 days. And an application in I number 7758 of 2024 has been moved, seeking its condonation. We'll allow the application, but we'll delay we shall condone. The delay is not very long, and that some explanation has been offered in the application, which is supported by the affidavit. First, in view of that, the delay is application is allowed and delay is condoned. Next paragraph. Learned counsel appearing for the respondent employee draws our attention to the decision in WPC. Is it coordinate bench decision? Single judge? No, coordinate bench. Coordinate bench decision in WPC number. You have written that?
WPC number is 8102 of 2019.
2019 is moved off on 11/5/22. White order dated 11/5/2022. Broadly in favor of the employee himself. Employees of the kind. First of all, we are also told that this order was carried forward for being challenged in SLP diary number
33400
of 2023, and the same came to be negative. Wide order dated just look at the order
25/7
25/7
2025, madam.
2025. First of all, thus the particular view of the coordinate judge having been judges coordinate bench having been secured imprimatur at the hands of highest court of the country, we cannot re-examine the issues canvassed before us. First, in the above circumstances, this appeal is also accordingly disposed of. The impugned order shall be given effect to within a period of 8 weeks. 8 weeks, without leaving the respondent employee to one more round of legal battle. Cost may be.
Item 16. WBC 18864 of 2024.
My lord, pursuant to judgment dated 19/1/26, no compliance report is filed before the Lord's register of this honorable court.
Report is not
The kind permission.
any challenge or challenge.
Opposite parties have filed
SLP is admitted on grant.
Just recently I had got a message from Delhi. Also Calcutta office, they have communicated me.
When the order was made?
19/1/26.
19/1/26. When SLP is filed?
That is 7th of May, that's past page.
But there is delay. Suppose if appeal SLP was filed in time, we would have appreciated. All right, we will call this matter in the first week of July. When the Apex Court reopens? On 3/7 or 4/7?
July. 2nd of July.
Learned counsel appearing for the respondent.
My lord, I am appearing for Union of India opposite party number 1.
Union of India.
Union of India.
The opposite party 1. This is 1. The appearance is that.
Opposite party number 1.
Yeah. Learned the panel counsel, senior panel counsel.
So, my lord, CGC, Central Government Council.
Contesting this one is 2-2. I am contesting.
Learned CGC. 3 and so appears for OP number. Response number 1. OP number 1. No, response number 1.
OP number 1, my lord.
Learned counsel Sri so and so represents the contesting respondents. First one. The said private counsel draws our attention to certain e-records that show that the subject order. What was the order challenge? Which is that matter?
Regulational matter.
Order dated
29/1/2026. 19/1. So 19/1.
19 January 2026 have been put in challenge before the Apex Court in SLP diary number.
Diary number kindly, 28314. The first column, your
CNR number. CNR number. 102831.
At top, you can see diary number is there.
Diary number 28314 of 2026. Albeit after brooking dealing. First, he seeks a short accommodation in that connection. First, therefore, call this matter in the second week of July.
Third week, reopening.
Third week of July 2026. Okay.
Grateful.
Date appeal 532 of 2025.
Already this batch of cases is
Disport of.
Your Lordship, I have given. Last page is
Devra, have you seen this?
my lord. Last page is the order.
But delay will condone.
My lords.
Will condone that.
280 days and 231 days.
First, this should be that. Then this one.
One more matter later, can we come tomorrow?
That's proceed tomorrow. Next.
Item 18, Read Appeal 1715 of 2025.
This 17 is both matters same.
My lord, my.
Two matters are there.
Only the delay is difference. 280 to 31.
17. Connected matter also is there, not? Not. Have you started copy in the on your print? Don't put the government advocate to embarrassment because already we are putting a lot of pressure on them. Have you changed
only the delay 320.
No, you have to change all the factors, the appeal, etc., etc.
That is all that same.
Same.
Only the delay question, the paragraph 3, that is higher number, that is 4199 by 2025 and the 345.
Here it is 354 days.
324.
That is 183.
But the challenge is same WPC number.
That is WPC number, that is 36514
541
by 2014.
Change that, huh? Yes. Delay, rejection. That delay application also rejected. Yes.
Item 19, Read Appeal 33 of 2026.
Appeals are filed by the state involving delay of 223 days and 224 days. My lord, they have filed written objection to our condonation of delay petition.
Is by special assignment?
No, not special.
By Honorable Chief Justice?
Yes. Yes. But my lord, they have filed written objections. We are ready to pay the cost, my lord. Your lordship may allow us to pay the cost and condone the delay because that is the first obstacle.
Condone the delay because matter was hard already. Your lordship form, yes.
Formulated your lordship a question we have answered. They have also filed, but that affidavit which they have filed, I had not privilege to go through. My lord, last night only I went through and they have raised certain also information. So, my lord, I have filed an affidavit. They have filed an affidavit. To their affidavit, I needed a certain reply to their affidavit.
There are two writ appeals.
The same judgment has been challenged. If you also look to your lordship order number 3.
Condone the delay.
Yes.
We put this matter immediately.
Reopening week. We pay the cost in the meantime, my lord.
Has moved to the government.
Sir, this is that case. You also remember where the OPESA, they had taken a decision in the executive body.
No, I understand, but he was represented by the Chief Secretary.
Yes. That case.
We understand.
You also formulated the point and you also given them to answer. Even my affidavit, I will also ignore. I can argue on their affidavit.
Yes. Problem. Appeal number 33 of 2026 has been filed after booking delay of 223 days. And an application in IA number 96 of 2026 has been moved, seeking its condonation. First off, application is supported by the affidavit. First off. Similarly, in the companion writ appeal, case in writ appeal number 40 of 2026, there is a delay of 224 days and application in IA number 116 of 2025 or 26 it is. 2026 it must be.
Yes.
2026 has been filed seeking its condonation. Here too, the application is supported by an affidavit. You have not filed any objections to.
No, I don't write.
No objections are filed to the said applications. In our considered view, rightly.
Objection filed. They have filed an objection.
You also condone the delay.
Your lordship, in fact, was hearing both on merits and limitation.
Some objections have been filed in writ appeal number
40 by 2026
of 2026, opposing the application for condonation of delay. Next pattern. We have Darul the applications and the affidavit that support them. First, though delay is been long, a plausible explanation has been offered as to the circumstances resulting into that delay. First, rejecting the appeal on delay per se would not do justice to the appellant. First, if delay is condoned, no prejudice would be caused to anyone, more particularly when such condonation would be subject to the precondition of making payment of rupees 5,000 to the OPs, to each of the OPs. Each of the OPs.
Each of the respondents will not.
Respondents.
Each of the respondents.
Yes.
But there are 59 or.
Correct. They are not getting salary from 2019. Suppose if we give 5,000 rupees for all, they can buy one peppermint. That will not do justice.
They should have filed separate petition.
We do not. Anyway,
Anyway.
1,000 rupees to each of 1,000 rupees to
yes.
each of the
Great point.
respondents. Within 2 weeks. First off, otherwise, if payment is not made, these applications stand rejected, and as a consequence, appeals as well.
First, one more prayer, my lord. 2 contempt petitions they have filed in 2 written. No. I'm just.
2019.
No, my lord.
We are not receiving our salary, my lord. They have stopped.
My lord, they have filed contempt petition. In that contempt petition, we have filed, my lord, our so-called affidavit. They are heavily relying upon the so-called affidavit in this 2 writ appeal. Those 2 contempt petitions, your lordship have already restrained them for not precipitating. May be placed before lordship for reference. We will also show your lordship that we had never complied.
No, how we don't have
no, for reference only, because they are not restrained already.
We can't take them in this paper. All right, are you pressing the contest?
We have a small prayer to your lordship, my lord. We have an appeal to your lordship conscience, my lord. Our appeal is since 2019 we are not receiving our
We are asking a small question. Whether these orders in respect of
Sir, we are already undertaken that we are not pursuing the matter. Feel your lordship, sir. Dispose of the matter. And that is why.
Next day to
yes, we also.
That day you are not supposed to take.
No. Only I was saying that reopening week, my lord.
But that is subject to making the payment.
Yes, definitely.
First you receive the money.
Sir, sorry.
We are told that the impugned orders are put in enforcement through contempt proceedings in contempt CP number so and so. First of in the witness of things, we the said proceedings shall not be precipitated by the complainants who are respondents here till next date of hearing. All this matter on 23. Yes.
This so immediately after vacation.
That is 21 day. 22 it reopens. We shall be celebrating your coming report
because you will.
We will.
Our entire difficulty is all these employees are not getting
23rd week. 23rd. Only very urgent.
Can it be at 2 o'clock?
Just
because you also have fixed on 6/5/2026, you also directed call this matter on such and for final disposal at the request of the council for both parties. That is what you also.
Yes.
Item 20, review petition 116 of 2026.
My lord, I am in virtual mode, my lord. Yesterday in review petition 119, arising out of the same input order, there is a delay of 46 days and I have filed an application for condonation of delay. Yesterday, your lordship called the matter, condoned the delay and directed for listing of the matter in the immediately after vacation.
Same order will make this, na?
My lord, I pray this may be tagged with the review petition 119 because both the cases are arising out of one impugned order.
Who appears for the OPs? We convert the 46 days. Order. Call this matter along with review petition number
119 of
2026. Only along with that. Because in that we have fixed the date. Yes.
Item 21, date appeal 1171 of 2025.
Yes.
There is an IA matter for condonation of delay.
Well, let the delay be condoned. No issues, there's only 20 days delay, let it be condoned.
A short delay of 20 days is proved in filing this appeal. First up, the senior advocate appearing for the respondents on instructions of the counsel on record very fairly submits that delay be condoned and main matter be heard.
Yes.
First up, we agree with this proposal. Accordingly, IA is disposed of and delay is condoned. Yes, we'll call this matter immediately after reopening.
On 24.
Call this matter on 24.
Yes.
Yes. No, 24 we have posted another matter, no?
25.
25 will have that.
Yes.
Yes.
Item 22, WBC 15925 of 2019.
Mr. Dear, we taken an after petition.
After vacation, my lord, in this case, hearing has already been completed. I have relied on the judgment of the honorable
What is this matter about?
My lord, that is the horizontal reservation case in which, my lord, both the post earmarked for the OBC has been gone to the ex-servicemen in the horizontal, my lord, reservation. So this matter has been hard in length, my lord, on last.
Heard by whom?
This, my lord, this.
By this bench?
Yes, my lord. The only issue I have relied, my lord, in the Rajesh Dharia case. So your lordship asked them to verify whether that case has been superseded or modified in subsequent order. They have given many judgments prior to 10 years prior to that judgment, 95 judgments, etc., which has no application at all, my lord. So till that my Rajesh. Yes,
on 25th. 25th of.
25th.
Do that. Next.
Item 23.
The request.
Item 23, rate appeal 1737 of 2024.
Yes, sir.
The case, my lord, the petitioner is the Lord's senior manager, Canada Bank, and he was charge seated, and punishment has been imposed. Reduction of 2 stages for 2 years and cumulative effect.
With cumulative effect.
Cumulative. The writ petition was filed. There 2 prayers were made. In addition to punishment, another prayer was made, promotion. That was not pressed by virtue before the court 10/1/23 order in the writ petition. That of 10/1/23. That was given up. And thereafter the matter was heard, and I have court has directed to me the submissions and all the violation of the rules that also I have submitted, and the violation of the rules also my submission, that is nothing has been done.
Your opponent.
Yes, bank is the.
You are the responsible.
And I have filed the complete submission, short submission I have filed. Also the points of argument and judgments also I have given. If your lordship permit, I can.
Not now. Because this is a disciplinary proceeding. Now requires a deeper examination. In hurry, we cannot decide such matter. We'll have it on 30th of July.
After holiday?
After vacation. Yes.
Item 24 has been adjourned. Item 25, date appeal 2320 of 2024. T5.
Some items delivered, etc. We can hold the service complete here.
Submission I have made complete. Complete submission I have filed. And actually court has dealt with the promotion also.
Although it was given.
Although it was given up. And the inquiry has been made only on 2 dates.
No, not that. Question I service of notice.
On party.
On party.
Party.
5C.
Notice.
1256 who appears? Item delivered.
We have the all for the bank.
You are for the bank. OP number?
All
OPs.
Yes.
All OPs will appear.
Yes.
How can that be?
My lords,
It will be for the
my
bank.
lords is talking of 24, item 24.
Correct.
24 is will take.
Okay. This is different. No.
In first hour, he mentioned that he will take.
2 p.m. it is.
He will take fresh steps for issuance of notice.
Yes, correct. Yes.
Item 25.
25, the senior counsel who was appearing for the appellate, he died, Mr. Santosh Patnaik. Now the corporation has decided to entrust the case to me. I have spoken to my associate who is appearing for the respondent. Also may call this matter after vacation.
It is submitted at the bar that Mr. Santosh Kumar Patnaik, a senior advocate, has passed away. And now, in his stead, Sri so-and-so, the senior advocate appears. And he seeks a short accommodation. First, call this matter after vacation.
Item 26. Date appeal 3103 of 2024.
Item 26, my lord.
Yes, sir.
May I pay for tomorrow?
Tomorrow?
Why tomorrow, my lord? I am explaining. My senior is I am dependent from the panel since 9th January.
You said that other day.
What is happening in some cases, they are authorizing us to conduct the case. No authorization in this case. If I take instruction, Monday. So that
the other day, less matter, sir. 20th. On request of.
I think yes.
Doesn't have the antenna purposes will be taken at 2 o'clock.
26 and
27.
27. That 2.
Yes. Item 28. Rate appeal 426 of 2025.
After the appellant.
Yes.
After disciplinary proceedings, in dismissal case. So last occasion, my lord had directed me to file a detailed date chart with the events. That also I have prepared it. But I have also prepared a short date chart showing some important dates for quick adjudication by your lordship.
Mr. Padin is also appealing in this matter.
No, sir. I'm happy.
Next one. Any urgency in this matter?
It's a writ appeal of 25.
25. We'll have it in the first week of July.
Yes, ma'am. I have got written notes. I have also prepared if your lordship.
You supply those notes. We'll go through in the meanwhile.
Yes, ma'am.
Yeah.
My lord, list of citations also I am giving.
You have you served copies of?
Yeah, just now I am serving.
Thoroughly.
I am giving.
Yeah. Rulings also you give.
Yes. The date chart, detailed date chart as per your direction. Last time I am submitting.
That also you did.
It has been.
Check.
I have all copies.
Now take the list of authorities, rulings he is giving.
Yes, yes.
Call this matter the second week of July 2026.
Item 29. Rate appeal 766 of 2025.
Brother, we'll have it in third week of July.
As your lordship please, madam.
Yes.
Have you provided? But he wants
third week.
He's asking that from lordship would he wants your lordship to hear this matter.
Yes, next.
Item 29. Rate appeal 766 of 2025.
Also, I'm preparing for the response. Now, the state has preferred this appeal. They have challenged the order passed in original application number 3551 of their 2017 month, where
Well, you are not the appellant.
My lords,
It's a common.
this
Covered
is-
matter.
this
Covered.
seems to be covered.
You that. Which is that judgment, brother?
Your lordship may confirm the judgment order at page 21.
The single judge's order, na?
26/6/2024.
Yes, ma'am. Yeah, another matter similarly, the same order was passed earlier.
Dismissed. Delay how many?
There is no delay. There is no delay. Condone.
234 days, the delay condoned. Already condoned.
my lords, please.
No, which order, in terms of which order we have to do that?
It is the 19/1/2022. And you have that.
Fine. Ah. Ah. Yeah.
Item 30. Rate appeal
Yes,
1227 of
30 days,
2025.
30 days are urgency, but I cannot argue any further because he is saying that the council's father is not well. But Lord, I have great urgency for me, my Lord, because they have encashed my bank guarantee while the pendency of this writ appeal, which was the subject matter of challenge, 4 crores. And your Lordship will be pleased to take it up on Monday at some particular time, my Lord. I have
I can't, now already they have encashed.
No, they have encashed, but they have encashed very wrongfully, my Lord. That's the position. I'll tell you, because I'm not going to merit because of this. But otherwise, my Lord, if your Lordship will hear me for 5 minutes, your Lordship will be satisfied I have a case. 5 minutes, please. 5 minutes. Lord, I have not taken any benefit from the central government. I have not taken any benefit from the central government. It was an incentive scheme. In the incentive scheme, my Lord, when I asked them that I cannot do it because of Ukraine war and other things, it was a government incentive scheme for the food manufacturing sector. When the incentive was promised that if you do this, you'll get 10% of the incentive. After 3 months, my Lord, I said that because of Ukraine war, I cannot do that much of. That means 80 crores for the project. Kindly reduce it. They did not reduce it. Thereafter, my Lord, twice I said, please do that, please do that. There was a fire. I have not taken a single incentive from the central government. Thereafter, my Lord, they said that we'll encash a bank guarantee. Because the bank guarantee was for that if I take an incentive, I do not do it, the incentive will be encashed by them. And since I've not taken any incentive, I went to the Honorable Single Judge. Honorable Single Judge said, allowed my writ petition partly. Said that you look into this, whether there was a cause of action for force majeure clause is there. They said that you look into it. So there's a force measure. But second part that they cannot encash my incentive was not allowed, for which I approached before Lordships. Then during this pendency of this case, my Lord, they asked me to renew it. I did renew. They encashed it. They can't encash, my Lord, as for the Raman Foundry case, my Lord, long back. I have got a copy of the judgment. A benefit given only can be taken back. No benefit given to me by the central government. They have not given a single benefit to me. So I said the single judge, with this did not found favor with the Honorable Single Judge. That's the reason I have challenged in that. But they directed the Honorable Single Judge that look into the force measure clause. They have not finalized that. Whether they have force measure or not, they have not finalized. While
even that is not finalized.
Not yet finalized. Part of the writ which is allowed.
That they encashed the.
Before that they encashed. While the pendency of writ appeal. Writ appeal was for an additional point. But they encashed it without complying with the Honorable Single Judge order, whether there is a force measure or not. So that's the reason 4 crores they have pendency of this writ appeal, Lord. That's the reason. Let me call it on Monday or Tuesday. A particular time, it does not take more than 10 minutes.
On the 20th?
Sir.
How many matters, sir?
7.
7. Put takes matter.
Grateful, sir. I'll remind your lordship. Grateful, sir.
Item 31, 32 have been adjourned. Item 33, WPC 8175 of 2025.
32 adjourned.
It's time for. Yes. I'm for the respondent, contesting respondent.
My lord, I am from the petitioner. On behalf of Mr. Pushpal, I am suspended for an also.
The.
Next week, any urgency?
There is no urgency. We are afraid for challenging the order of Pillar Planning Central Altitude Tribunal for Pillar regulation.
Regularization.
Let's may call this matter petitions.
Call application.
Publish. My opinion is good.
Item 34, WPC 28010 2025.
You're not paid counter. File counter to be filed within 2 weeks, failing which right to file one stand forfeited. Make it 3 weeks. Call application.
Item 35, WPC 28590 2025.
Small matter, it's a pursuant by notice for sale. I have responded and being a successful bidder, deposited 25% of the bid amount. Since it is in 2018, Oxford said, till that they are not in a position to deliver the
Possession of the property.
But I have deposited only 25%. There was a lot of litigation going on, and on the date of auction, there was a case pending before this honorable court, and honorable court has directed that some order which was in the sale notice, they didn't publish an corrigendum to that notice, revealing that that case is pending before this honorable court. My lord,
it was held by CORAM. Direction was to the loanee to pay the rest amount. My lord, last occasion, Lord, was directed to deposit the EMD amount. I have already deposited before register judicial 17,50,000.
My lord, that check may be given. My lord.
So I may let it come on after vacation.
How much money you have deposited?
I have
25% of the amount.
17,50,000, my lord. I'm a clerk of the organization, my lord. Since 2018, I have deposited.
No, suppose if they agree to give the interest on that.
I will take back, my lord. I have prayed for that, my lord.
My lord, he has prayed for to right now file an interim application to release the EMD amount of rupees 17,50,000. Accordingly, I have deposited.
You have deposited in the registry.
Yes, Lord. That is on record, your lord.
What happens to the interest?
Interest part, my lord.
Interest part, so far interest part.
Will adjudicate interest.
Yes,
subsequent. You take that money first.
Yes, yes.
My lord.
Whatever money is deposited, get it back first.
My lord, keep it parted and it.
Not parted. We will make part justice. We will do now. You will get back that money first. At least that money you will get part. Interest part will see.
It can be decided, my lord. I have got two judgments. I can
any case can be decided, including.
If it will remain, my lord, I know, my lord.
No, we'll say without prejudice to your contentions in the case. At least your client will get that money.
My lord will pass that order, my lord. 5-line short story of those movies, my lord. I am telling, my lord. A boatman is waiting in the Russian land. Boatman is waiting. It is evening time, and a beautiful lady came. She want to cross the river. The boatman. It was just it was happily ready. She came to the boat, and midst of the river, there are more downpouring happened, my lord. So she came, that lady, that beautiful lady came to the boatman and put her head on his chest. With that 5-10 minutes, they crossed the river. The beautiful lady get down from the boat and she paid the amount. The boatman looked at her, and after some distance she covered, she looked back and gave a smile, my lord. And I'm keeping the story here, my lord. I will explain the things, moral of the story on that date, my lord.
Well, I am sorry to say, you
want to tell one more story?
No, sir. No, your lordship. No, only.
We will say.
No,
I will also say.
No, your lord.
But case will not be decided.
No, let it come after. He has also failed to the in right time. After issuance of letters to pay the rest amount for issuance of a sale. He has failed.
No, he wants to send a message by that story.
Yes, sir. So
that message he has kept in. It is hidden now. It is
I am not.
It is wrapped in enigma. Let us see what the story morally will come from that next time. Call this matter. No order need be passed on refund of the money.
My lord, the passing order, good, my lord, but fixing a date, my lord.
We'll fix a date also.
Fine. 44.
By our order
date check, my lord, I have sought the copy of it, my lord.
By our order dated 25/3/2026, we had said as that first learned counsel appearing for the OP Bank. OP Bank submits that in terms of the above order, his client has deposited a sum of rupees 17 lakh.
That's 50,000.
50,000 in the registry. And he tells that the said amount may be remitted to the petitioner, subject to the rider that what interest should be paid or any interest is payable at all
by the court,
will be left for adjudication on the next date of hearing. With this proposal, learned counsel appearing for the petitioner is also agreeable, provided that some date is fixed for taking of the matter for final hearing. First off, in the above circumstances, the registry is directed to transfer the subject amount of rupees 17,50,000 to the bank account of petitioner. Do you have bank account?
Yes, ma'am.
Give that.
I'll provide. My lord, what has happened? That
bank draft is drawn in his favor. In whose favor?
Registered
judicial.
In view of the above, registry is directed to transfer the said amount of rupees 17,50,000 to the bank account of the petitioner. Do you have bank account?
I'll furnish, ma'am.
Which will be furnished by the bank account below. Bank account below. Correct bank account.
Yes, ma'am.
Because and give it in writing.
Yes, ma'am.
So that if there is mistake, amount goes to somebody tomorrow, you should not sue us.
I'll buy. My lord, what has happened? Must have happened. My lord, the amount must not have been deposited in the account, my lord. The register's account, because it is no order.
This is a draft.
Draft they have.
No, draft in favor of, drawn in favor of registered judicial, no?
Oh, yes.
So it must be there.
Yes, sir.
So it has to go to, it hardly needs to be stated that the bank draft for the said amount should be encashed by the registry and remitted to the petitioner's bank account. Below. That way to structure that order, just draft show it to and then do that.
My lord.
Yes, sir.
I had the opportunity to go through the papers, newspaper. My lord has quoted 2 quotations in a judgment over duty and quoting from the Khalil Gibran's. My lord, I'm giving the
Yeah.
Item 36, WPC 33925-2025.
Item 36, they filed the counter with the agenda. But most of the issue is that we want the succession certificate by which you can ready to pay the pension. But after 10 years, this coming that I am the wife of the deceased, but in service book there is nothing. Everywhere is nil.
My lord, I have produced legal certificate. And the law is well settled. Succession certificate is not required, my lord. But they have imposed me the succession certificate be produced. Inquiry report. My lord?
How to ascertain that the claimant is the widow?
My lord. Because she has produced legal heir certificate. Aadhaar card is there, my lord.
What?
Aadhaar card is there, and a legal heir certificate is there, my lord.
When husband died?
2004.
2013, my lord.
2013.
14, my lord.
2014. What is service register? Her name is not reflected.
Not there. Everywhere is written. Lakshmi Siddhi page 101. And the form. Everywhere is written. So this is died.
What was he?
My lord,
he is working as a sub-postmaster, Badampad in district of Bajwaj. A sub-postmaster declaring that I didn't have any spouse. And spouse, when the revision is coming, you told no.
Marriage happened when?
Marriage was not with
my lord. Marriage scheduled caste person, my lord, and their marriage is not recorded in the registration.
No, when the marriage happened?
My lord, in the year 2000. My lord, my file is not with me because sir has told to take time, my lord.
All right, call up.
My lord, after vacation, your lordship will fix a date, my lord.
Yeah, first week of July. First week of July. See, Hindu Marriage Act. Hindu Marriage Act. Hindu Marriage Act is not applicable to scheduled caste, scheduled tribe people. Not, it is not that scheduled caste people are exempted from the act.
They are not exempted.
Whether they are scheduled tribes. Scheduled tribes is a scheduled tribe.
My lord, my file is not with me.
Anyway.
My lord, your lordship.
Title mine is coming in scheduled caste.
Right. No, not necessarily. They may come under scheduled tribe.
Tribe also. For scheduled tribe, the act is not applicable. That does not mean there should be no ritual for marriage. Otherwise, everybody may claim that I am the spouse or I am the.
My lord, legal heir certificate, they have not disproved.
No.
They have not challenged my.
Lesson there, we are paying legal certificate. But there is no proof. You cannot accept blindly that he is coming and after long time he is coming and saying that
a person has gone to the village and told that she is not married lady. That is their inquiry report.
But at least some material for marriage.
Well, material.
Except that the what is that certificate?
Aadhaar card is
legal
there.
heir certificate.
Well,
it is for some other purpose.
My lord, your lordship, see, legal heir certificate and law is all settled.
Where is the settlement law?
My lord, two decisions I have cited, my lord. One is the Odisha High Court decision and Supreme Court decision, my lord. So keep it in June, my lord.
June?
My
lord. Keep it in. Next.
Item 37, WPC 11400-2026.
Yes, this case. The property in question, I have come up before lordships that the mortgage property was put to sell by auction, and auction it was sold, my lords. And I came up before lordships saying that whatever the amount has been given and outstanding, and as well as the interest to be paid to the my lords purchaser, because that is the only residential house, my lords. Nothing. So that option I had given to lordship.
Whether the auction buyer is here.
Lord, I am appearing for the auction procedure. Lord, you could kindly look at the prayer. I am citing two judgments. This rate picture is not maintainable.
No, but what the very beginning I said that
kindly see
judgment is not maintainable. I don't dispute that. Only question is because only residential house.
No, it's not a residential house. I know this. I have seen this property while passing to Puri. It's a commercial property. It's a restaurant besides a petrol pump. And this property has been sold to auction once failure. Second auction, I am the highest bidder. He is challenging the 14 order. As per Hon'Ble Supreme Court, 2 judgments I have given. It's a clerical ministerial job only. And section 14 order is applicable on section 17. There are 2 judgments I have given, my lord.
When that order was passed?
Not the section 14 order was passed on, kindly see Annexure 6, my lord. That is
January 26.
Yes, my lord. January
26, but possession has not yet been taken. That is why
the collection has passed the order. It's a ministerial job only.
No, I'm not disputing what my friend is saying. Very beginning, I'm saying that it's not strictly speaking, it is not maintainable. Only because I'm saying that I will redeem, pay the entire dues, along with the interest that is payable to the auction purchaser, the amount he deposited. That is why I had to come up before Lord.
Kindly see page 18 of my compilation. Kindly see, para 20. 1 second. Only 2 pages I'll show to your lordship.
No, but he issued this notice on your submission that it's a residential house.
No, it's not a residential house.
No, that is my abhorrent. He has seen it personally. I have seen it personally.
Visited the restaurant. I have taken my lunch there. I have seen this.
Sir, from bank, I am to submit that this property is already registered with the sub-register.
Not registered. Not registered. Not registered also. Sir, in the SARFAESI Act, when it is sold, that sale certificate is registered.
You are for buyer.
It is registered in the book number 1. So that is how it is solemnized in the shape of a sanction certificate.
It is not compulsorily registrable.
No, it's not compulsorily registrable. It is entered in book number 1.
Number 1. So that it becomes notice to all that.
Yes,
that you are the owner of the
That's right. And that is complete also. That is complete.
On I admittedly 7-4 self-certificate is issued. I don't dispute that also, Lord.
No, but he is not agreeable to receive compensation, which we wanted to give because like order 21 rule 58 or something like that, where the auction property, where property is auctioned and the owner of the property wants to compensate the auction buyer. There is one provision, article, Order 21 rule.
Subject to consent of the buyer.
Yes. That way we wanted to make this arrangement. But if he is not agreeable, then we cannot interfere because it is not a housing property. It's a commercial property.
That my abhorrent is that. So Lordship, now it has been done. Lordship only give me 2 days time. I will verify if it's not a residential house. Because on that score only Lordship wanted to notice saying that if it's a residential house. If my friend says it's not a residential house, I will take that instruction.
It is popularly known as 7 on restaurant besides Puri, Bhubaneswar, National Highway. It's a restaurant, Chinese restaurant. I have taken dinner, I have taken lunch over.
No, he never invited me. It's not discriminating. He never invited me.
You have not invited your
Mr. Savitri, they were not fighting the case for them.
When you both go, then we say we also should be invited.
But when it is operational, I'll carry him. Definitely.
On this matter.
Pass over item 10.
25-6.
Grateful.
Item 11, the bank's pension matter.
Yes.
Sir,
that 11 was there, my lord, says.
No, first we will have that advocate general that one.
My lord, London Advocate General is seeking only 10 minutes accommodation. He is on the way.
No problem. No problem. We will wait for the advocate general. No issue.
10 minutes accommodation.
Yes.
He is on the way, my lord.
The other matter, Lordship, item number 11.
11.
Yes.
It is urgent to tomorrow.
Tomorrow. What and all?
It is urgent.
Tomorrow,
Tomorrow AG may say that he is inconvenient because this is being adjourned from time to time.
Only, but the AG wants to attend. AG wants to argue this matter.
Okay,
Therefore,
That ठीक है. Tomorrow if AG says
we'll try.
we have no problem. May I pray that you Ranchi fixes.
There is only one AG for all these courts. How can we expect him to be in every court? Plus, he has to have some matters in the apex court also. Very important matters will be there. We can't do like that. We have to.
So I also take it up tomorrow.
Let it come tomorrow.
Which
is that?
Item number 2.
Yeah, call 10.
Item number 10, WBC 14980 2026.
Green motors.
Item number 10.
You were not there when it was called, na? Yes. Which is that matter? Some bank coercive proceeding.
Greenway Motors, Nagar. So perhaps motors.
Section 14.
Section 14. Surface.
Tell me 526. Day before yesterday. Right? Who is the lawyer? Commercial will cross. 114 is passed. He should challenge that order and respect the more there and keep it. Let him go before the BRT. Section 14 it is.
This is section 14. They can very well avail the under SS 17. They can. And no one is for the petitioner, my lord.
Yes. Petitioner borrower is knocking at the doors of the High Court for assailing the coercive recovery proceedings that culminated into order under section 14 of the Surface Act 2002 on so. Next paragraph. Very many grounds have been taken up in the petition for assailing the said order.
This is my lord, OP number 1.
1, collector.
Collector come district magistrate.
That submits, and we agree that against the order of the kind, redressal can be had
under section
17 of the 2002 Act before the DRT if grounds do exist therefore. First off, no extraordinary circumstances are demonstrated as to why the Constitutional Court should grant interference in matter like this. First off, in the above circumstances, this petition is full of preserving liberty to the petitioner to avail the statutory remedy as indicated above or otherwise elsewhere in accordance with law if grounds do avail therefor. First off, registry to send a copy of this order to OP number 2 bank for its file by speed post immediate. Yes.
Item number 27. WBC 17676 2024.
Petition number.
minutes, request for 5 minutes, my lords. Learned AG is just coming, my lords. Learned
It's coming.
Yes, please.
But back in the day, sometimes as a holding arrangement, the courts would always say so and so start, and then others would join in. Back in the day when we started practice, we sometimes got an opportunity in that sense to occupy the case and address the court.
That's it. 1967 judgment of the apex court is referred to by the Delhi court also. Delhi judgment.
Yes.
Which other day you pointed out. And Delhi judgment is referred to by 2 coordinate bench judgments. One final aspect we wanted to know, more jurisprudential aspect. How apex court granted relief in a case under the provision which availed as vis majoret. 67 judgment which you read the other day.
Yes.
Do you recall that?
Yes, my lord. That Gujarat Pottery, I think.
Name I do not know.
Yes.
It referred to mining lease itself.
That is Gujarat. Yes, Gujarat. 5 judges.
1967?
Yes, ma'am. Gujarat Pottery, which I said.
Kindly read that one particular paragraph.
Yes, ma'am.
When I said other day, how vis majoret clause can be, the benefit can be taken even in a case of non-vis majoret. Then you read that judgment.
Yes.
Kindly read that paragraph.
Correct.
Out of jurisprudential interest.
Yes,
we are asking.
Yes. Yes.
Only for knowing.
Yes.
Suppose if that order is otherwise attributable to Article 142, then 141 is excluded. If 141 is excluded, you cannot much draw milk from that judgment in your favor.
Yes, please. May I read that line?
Yes.
But we had given a compilation, so I take it your lordship. I'll just read it.
We remember, just read.
Yes, ma'am. It is really the sanctioning of the lease which amounts to granting of the lease. The execution of the formal lease is only compliance with the legal requirements to make the grant legally possible. Are the operative lines which I read?
No, vis majoret clause.
Yes.
One paragraph is dedicated by the apex court on vis majoret. I would benefit of extensions and also let's see different.
Sorry, by mistake. I think it's a Delhi judgment. It's at page 35 of my compilation.
Not Delhi judgment. Delhi judgment we had gone through that. We have read Delhi judgment.
May I just...
You referred to 1960 apex court judgment. One particular paragraph from which other day you said memory we are seeing.
I'm exactly reading that line.
Yes.
The expression force measure has been held to mean A, B, C, D, E.
Yeah.
Next line. Though this is not a case of force measure, in terms on analogous...
How we should pronounce it? As force majeure, this is what our professor who was teaching, he was a student of Winfield, who wrote, taught, Winfield and Jolovich. Yes, he was his student. He used to call it as force majeure. Yes. I do not know.
I did say FFPB. It takes care of the communication part.
Yeah.
I'll just read it again. Though this is not a case of force majeure in terms on analogous principles, it appears to us, and these are the crucial words, that the unlawful interruption of enjoyment caused to the lessee by the illegal act of the respondent is something that the lessee could not reasonably prevent or control, and the period of this interruption should be excluded from the term of the 3LS. Not to do so would result in depriving the petitioner who has been prejudiced.
But then the court said what? Then relief is moulded what way?
In this case.
Yes.
Then, my lord, I'll just read that. 37. Para 14. Lord, the relief is followed. Allowing the petition, we issue a writ of mandamus to the respondent to restore possession.
Respondent is
the state.
Union
Union of India in that case.
Yes.
I think it was Haryana government, if I'm not mistaken. It was Haryana and Union both, but state in that sense.
Yeah.
We issue a writ of mandamus to restore possession and direct that the period of unlawful interruption shall be excluded in computing the term of the lease. Exactly the relief that we asked for in terms of the contractual stipulation in the lease.
How Delhi High Court has treated this?
Yes. Now, my lord, Avtar Singh, which was Delhi High Court.
This is so apex court citation is?
This is ILR 1988. Roman.
No. Apex court judgment appears to be 67, 68, something like that, na?
No, apex court was Gujarat, Pottery, 5 judges. On the grant order is the one which vests the right.
Correct. No, that is reported?
Yes, madam. Apex court is AIR 67 SC 967.
How many judges?
964. Madam, five honorable judges.
By judgment decision it is?
Yes, madam.
Kindly see.
Yes, madam.
You are sure?
Yes. Justice Subbarao, the Chief Justice, Hidayatullah, Sikri, Bachawat, and Raghubar Dayal. Now, madam, this is applied in the following.
No, only this much we wanted to know. Nothing beyond that.
Yes.
Now, Learned Advocate General has come. That is. We will just have Mr. Acharya. No. Thank you for being here.
My apologies. In fact, at times not.
No problem. We understand there is only
my
one
told me today. In fact, it's a.
We understand that there is only one. There is a sole Advocate General in this.
No, that is not.
Therefore, naturally, will be held up in this one. We understand that.
So
we will have some clarification as to what the apex court did in 1967 SC 964 from counsel for the petitioner. Now you can start. You can begin from the stage where we had left other day.
Let 67 Supreme Court that Gujarat Pottery works. So, that is on a different context. I'll explain. So, Millard, if your lordship to recapitulate your lordship's memory, I have shown to your lordship the provisions of the MMDR Act, especially Section 8 capital A subsection 6. That is the crux of the matter.
That beyond 50 years it cannot be.
No, not only beyond 50 years or till the last date of renewal.
Whichever is later.
Later. So I was submitting to your lordship that 13th August 21 was the last renewal date and no extension thereafter. That is the mandate of 8A6.
Now, this lease in question was granted when?
It was granted long ago in 34. We are not on that.
37.
50 years is over. 50 years is not the issue.
Kindly read that section.
It is 6 million. 50 years admittedly has expired.
Now, from which point we have to reckon? to say it is 50 years. From which day we have to reckon? How that is
From the
treated?
date of initial grant? Initial
Sure.
grant?
Yes. Mindset.
8A6.
No, Mines Act itself. Mines Development and Regulation Act, na?
MMDR.
Section 8 capital A,
Subsection 6. Let 3 and 6, your lordship, may read together.
Section
3 and 6. Subsection 3 and subsection 6 both. 2, 3 and 6.
Section 3, 2, 3 and
6 Milan. Should I place the whole section? So it would be better because all are connected.
Correct.
So the provisions of this section shall apply to minerals other than those specified in Part A and Part B of the first schedule.
Yeah. Yours is not Part A, Part B. Therefore, section is applicable.
Right. On and from the date of commencement of the Mines and Minerals Development and Regulation Amendment Act 2015.
It is from which date? 12/1/2015.
2015, this came into force.
Date, it comes from a date.
12/1/2015. Lordship is correct. On and from the date of commencement of the Act, all mining leases shall be granted for the period of 50 years. So this is for future.
Once. This section contemplates grant of a mining lease.
Grant of period.
That's what.
Period.
But those who already granted,
they are covered. I'm showing. So, Milord, this is after earlier, Milord, there was no 50-year ceiling.
Correct.
It was for even 60 years, 70 years, 20 years, then first renewal, second renewal, like this, Milord, it was going on.
Correct.
So even many people have enjoyed it for 70 years.
Yes.
As in the instant case, maybe it is a 1934 ledge. So
yes.
this particular ledge. So subsection 3, Milord. This is for, Milord, the leases which would be granted after the commencement of the Act, the period is 50 years.
This lease
new leases. No, after the
new lease.
Now,
you are right.
This deals with the new leases
to be granted.
But so period is 50 years.
It is already granted.
They are covered. I'm showing one by one. All mining leases. Milord, we are concerned with this.
Correct.
All mining leases granted before the commencement of the Mines and Minerals.
This amendment
Act shall be deemed to have been granted for a period of 50 years.
Even if it is 3 years.
3 years.
It shall be deemed to
No, there is no 3 years, Milord.
No,
it is,
yes.
Lordship is correct. Lordship is correct.
To explain
understand
and
it.
taking yes.
No,
because logically that will impress the human mind.
No, that's correct.
Yes.
That's correct.
If it is given for 300 years,
it
shall be deemed to be 50 years.
By this
It
creating
is
this
given for 3 days, it shall be deemed to be 50
years. Lordship is
That's
correct.
correct?
Your Lordship is
The
correct.
next section.
Yes. So on the expiry of the lease period, the lease shall be put up for auction as per the procedure specified in this Act. Earlier, Milord, there was no auction concept. So after this January 2015 amendment, we went to the auction regime. It was not earlier there.
We want to know whether this subject lease, property comprised in the lease, is put to auction.
No, Milord. It was an earlier lease granted in way back in 1934.
On being asked, learned Advocate General very fairly submits that the land which is subject matter of lease in question has not been put to auction as yet, as provided under subsection 4 of section 8 capital A. Okay. Next point.
Just
Provided.
This point, it's because it's protected by a Supreme Court order of 4th February 2022.
The senior advocate appearing for the petitioner interjects and says the auction has not taken place.
There's a status code. I'm saying
Since there is a status quo order handed by the apex court in.
Yes, it's dated 4th February 22.
4th February 2022 in.
Yeah, just come. And extended, my lord, on 2/12/22.
And extended on
bracket made absolute
2022
in SLP Civil.
In SLP Civil
1565/22.
1565
of
2022 between
petitioner and respondent.
Between the petitioner and the respondent. Between the same parties. Between the same parties. Okay. That is one where the coordinate bench denied you the extension of 10 years.
Yes.
That is put in challenge.
Okay.
There that order is made. Understood.
On the expiry of the lease period, I have the procedure specified, etc. It will go to 1 section.
Then one more question arises to you.
Yes.
If we direct them to extend the period,
yes,
then there is a bar under the status quo order. What will happen?
No, that bar status quo is not quite this because this is in the 20-year. My add back is in the 20-year period.
This is a 10 plus 20. Yours is 10 plus 20.
I'll say 20,
no, 20 plus 10. 20 plus 10.
Provided that nothing contained in this section shall prevent the state, that thing may not be confused with this. Is a, your lordship may kindly appreciate.
No, that only says, suppose more than after 50 years you are auctioning, but auction may take place in advance. The proviso indicates for holding auction, you need not wait expiry of the 50 years.
That's correct.
In preparation of that, you can do auction.
That's correct. That's correct.
Next.
So once, my lord, that statutory period is over, my lord, it has nothing to do with this. By operation of law itself.
Correct.
So it goes. So 20 years extension has nothing to do with this period which he is asking.
Correct.
Beyond the renewal period.
Correct.
Provided that nothing contained in this section shall prevent the government from taking an advance action for auction. Your lordship was putting this.
That's one. Next.
Of the mining lease before the expiry of the lease period. My lord, 5 we are not concerned. Your lordship may straightway, or should I read 5 million?
May not.
It's not.
Right.
It's not captive.
There is no reason to not
that correct.
Yes.
So notwithstanding anything contained in subsections 2, 3 and 4 above.
2,
3 and subsection 4. The period of lease granted before the commencement of mines minerals 1 so 2015, where mineral is used for other than captive purpose, shall be extended and be deemed to have been extended.
This is other than captive purpose only.
That's correct. Up to a period ending on the 31st March 2020. Let's have got it. This is the selling date. 31st March 2020, with effect from the date of expiry of the period of renewal last made, or till the completion of renewal period, if any, or a period of 50 years from the date of grant of such lease, whichever is latter. So, whichever is latter, this particular phraseology has been interpreted in common cause and etc. Entire subsection 6, that it is 50 years, 31/3/2020.
In other words, that will inure to the benefit of the lessee.
That will, yes. Even if it is beyond 31/3/20,
so
or 50 years also, but till the last date of renewal, a lessee can continue.
Correct.
Whichever is latter, subject to the condition that all terms and conditions of the lease have been complied with. But this is the short question.
We have understood that.
Yes.
First, refreshing our memory,
my lord.
Just tell us on which date the lease in question was granted.
1934. No, I have given. No, I have given a date.
14th August 2001 for this subject issue, not historical. We are concerned with 14th August 2001.
14.
No, my lord, that is how can, that, my lord, lease is from the initial date. Yes.
Renewal.
Yes, yes, my lord. That is the renewal date.
That
2001 was the renewal.
1 second.
The renewal for a period of
20 years. Whether word
20 years.
this is renewed for a period of
20 years.
20 years. My lord, earlier it was for 30 years. 34 was the initial grant. Subsequently, there has been many transfers from ownership, etc. My lord, that is under the statute, that period is not yet. But question is, my lord, here, or till the completion of the renewal period, let's say may mark it. 50 years is not the issue, my lord. 50 years is already complete. So last renewal date is also complete.
In other words,
31/3/2020 is also complete.
In other words,
yes.
3 circumstances are contemplated.
Right.
Under section 6, subsection 6. Of them, we relate to only one aspect.
Right.
That is the renewal period.
The renewal period.
Yes.
So renewal period, my lord, as I have been repeatedly saying, 13th August 21 was the last renewal period. And that covers all the earlier things, my lord, 50 years, 31/3/20, and the last renewal.
Correct.
So Lord, now the question is, let me not show all the annexures also I have shown to your lordship. The contention was that in the absence of the environmental clearance, the deputy director passes an order not stopping the lease to carry on the mining operation because there has to be statutory compliance. So in 2015, the government of India, my lord, says that it is valid till the renewal period, end of the renewal period, but subject to Hon'Ble Supreme Court's order. Supreme Court passes an order.
No, the first sentence you have to show us. We understood the
annexure 9, I think.
Annexure
9. Government of India's. 1 minute, subject to correction.
The lease as such is not rescinded, Mr. Acharya. The lease as such is not rescinded.
No.
Mr. Acharya, on being specifically questioned, answers.
These are died in natural death, Miller.
The renewal lease dated 14/8/2021 has not been rescinded.
No, it dies there.
Only, you said that we have just recording.
By operation of law.
But only the working of the lease has been interdicted by the Deputy Director of Mines Wide Order number 1554 dated 31/3/2014 at Annexure 9. The lease as such is not rescinded.
Yes.
Because law relating leases. At least one famous book, of course, Mullah treats it, Mitra also treats it. There is one good book I did not find in your library. Law of Landlord and Tenant, written by T.R. Andharujina, the former Solicitor General.
Right.
There is a difference between interference of the landlord in the enjoyment of the lease,
right,
and rescinding or determination or termination of the lease. In
so
that
here
context,
will not be termination, yes. It is that yes. There is no termination. It is
very fairly
by operation of law.
Termination of the renewal.
It is not required, my lord. By operation of law, it lapses. There is there is a statutory prescription of the lease period. So beyond statute, my lord, someone is not authorized to operate. So there is no formal. We have to formally, the period is over.
When period is over?
13/8/21, my lord?
No, 21 all right. But period during which he has been prevented from operating the mining lease.
My lord, prevention was on account of the non-availability of EC.
That's all.
So that's correct.
We will examine that. That's good. The factual position we will first assert. Then we'll apply the law. Yes. Yeah.
So, Your Lordship may then kindly come to, I was referring not 9, it was annexure 14.
Incidentally, we had asked you other day, what is his authority to pass an order of the kind? Where is the authorization to you?
Authorization is there, my lord. I was showing the, yes, Deputy Director, my lord, under law.
Kindly show.
He is, my lord, there is, Your Lordship, yes.
Kindly show them.
So, my lord, any mining operation in the absence of any of the statutory requirements or clearances, etc., because it is subject to compliance with the laws of the land.
Correct. Can our assistant registrar of the High Court,
right,
on that ground prevent the mining operation? So there is a competent authority.
No, that's correct. He is the competent.
Yes.
Same thing, data there.
Please.
No.
Data population. Data వచ్చిన సిద్ధం.
You don't have second copy?
So we have given two copies. Mr. James, it's you need one. I will do the page for the second. But any mining operation, now therefore in exercise of power conferred under section 22 copy. You can read. Powers conferred under section 22-23B of the MMDR Act, the state government have been pleased to authorize the following officers to exercise the powers of detection, seizure, confiscation, etc. in connection with illegal mining activities covering the entire state of Orissa under relevant provisions of the aforementioned act in respect of the area mentioned against is further they are declared as competent authority as defined in Rule 21B of the Orissa Minerals, etc. from the date of issue of this notification. But he is the authority under
it refers to several sections. Kindly take us through
22 and 23.
Yes.
Let me just explain. Any mining operation without the statutory requirements, etc., mining plan, environmental clearance, forest clearance, consent to operate, these are the 4 requisite documents.
Whether illegal mining is defined anywhere?
Yes.
Sure that.
Illegal mining, this particular environmental clearance, the common cause Supreme Court said that even environmental clearance,
we are, yes, Acharya. This we call in administrative law as a delegated legislation or subordinate legislation.
Right.
Therefore, we are asking you,
yes,
which is the provision which delegated the power so that we can decide the scope of this instrument.
Section 22 and 23.
Let us read that. Sections 22 and 23, capital B.
Right.
Let us see what they have delegated.
If any gazetted officer of the central or a state government authorized by the central government or the state government as the case may be, in this behalf by general or special order has reason to believe that any mineral has been raised in contravention of the provisions of this act or rules made thereunder, or any
document rules made under means what?
Any rules made under the act?
This act. The clearance is issued under which act?
Under the Environment Protection Act.
That is not protected here. Can you read the section?
In contravention of the provisions, rules made, any document or thing in relation to such mineral is secreted in any place or vehicle, he may search for mineral document.
No, not that.
Provisions of section 100, etc.
No, not that.
23C, my lord, the power, there is another set of rules. Rule itself authorizes.
At least because your notification, join and join on.
No, there is a rule also, 2007 rule. Here, my lord.
No, let us understand this first. This you are leaving now.
23B, my lord.
No, are you leaving this section?
I am leaving.
Are you leaving this, giving up this section?
No, I am not giving up.
Then
It is
come
to
to
be,
this
my lord, there are several safeguards. My lord, your lordship, there are several statutory safeguards for the purpose of preventing illegal mining. No section, my lord, is to be read in isolation.
No, I will not.
A competent authority, my lord, who is enjoined with certain statutory powers on being either delegated by a statutory notification or under the rule, is enjoined. Yes.
The small section. We are not that knowledgeable as you are because you have handled many such matters. At least my exposure is frugal. But I have some foundations on administrative law. Very humbly, I tell it to you. Because I may take you to the apex court decision, but I need not waste time. I assume that you know them. Now kindly come to section 22. Because this subordinate legislation which apex court called in Bombay judgment. This is a subordinate legislation. This is.
I'm not harping only on that.
Yes. Not only. We will go to other sections also.
Yes.
Let us examine one by one now. Section 22, let us read it. Whether you
Section 22, my lord, that's an offense.
Yes. Therefore, you concede. Section 22 does not give that power.
Section 22 empowers the government to, my lord, to authorize a person to, my lord, laws. Section cognizance of offense. No court shall take cognizance of any punishable under the rules made thereunder. Complaint in writing made by a person authorized in this behalf by the central government or the state government.
That
so, my lord, yes. So therefore, a complaint, when it is required to be filed, it is to be filed by the person who has been delegated with the power. He is the deputy director under his jurisdiction.
Let us read section 22. Read section 22. Please read section 22 again.
That is regarding cognizance of offense by a court.
Therefore,
in the event of filing of a complaint by a designated authority.
Yes.
So for the purpose of that conferment of authority on the deputy director, this notification has been made under section 22. That is for dual purpose, to deal with.
So we do not buy this argument.
No, that is not the case, my lord, here.
Gradually,
base is something different. Your lordship is delving into an area which is not the subject matter in control.
Is it whether?
No, I am showing. So therefore, I am showing.
Is it not prevented? Is it not prevented on the basis of deputy director of mines order?
No, my lord, I am showing that. Your lordship may kindly come to the rule 23C.
This we will not read now.
So, my lord, your lordship may leave it for the time being. If your lordship so far, I was showing the limited purpose of 23B, power of search.
We will read 23B.
Who yes, your lordship may kindly read it.
Yes.
If any gazetted officer of the central or state government, authorized by the central government or the state government, as the case may be, in this behalf by general or etc., has reason to believe that any mineral has been raised in contravention of the provisions of the Act, etc., made thereunder, or any document or thing in relation to such mineral, is secreted in any place or vehicle, he may search for such mineral, document or thing, and the provisions of so and so shall apply to such, etc.
Does it confer the power?
Let me explain. The deputy director is the authority for all practical purposes, so far his territorial jurisdiction is concerned, to deal with the scenario where the mining operations are being carried on in accordance with the provisions of the Act. MMDR Act is not the sole act because that deals with the grant.
Yes.
That is subject to
rules and other,
etc. Not only under the MMDR Act, but under the other laws. So otherwise, it has no meaning. So if he can carry on without the environmental and forest clearance.
On being asked, what is the authority of Deputy Director of Mines for issuing Annexure 9 order interdicting mineral extraction operation draws our attention to
That is formula.
Notification dated 19/12/2009, which textually refers to sections 22 and 23B of 1957 Act, amongst others, as authorizing him.
No, that's not the sole notification.
Therefore, amongst others. Therefore, I used the word amongst others.
That is
first. He reads out text of sections 22 of the Act, which speaks of taking of cognizance of an offence punishable under the Act or rules made under the Act, and who should be the competent authority to lodge the FIR or complaint. Beyond that, that section does not say anything. Next. Then he drew our attention to section 23B, which broadly gives power of search, inter alia, the power of search and seizure to a gazetted officer authorized specifically in that regard. First, we do not subscribe to his view that these two provisions on their own would delegate any power on a power to issue notification of the kind. Yes. Next point.
So that is not the power under which he has, my lord. Your lordship may turn to 23C.
Yes.
My lord, the
Let us see 23.
by power of state government.
Yes.
To make rules for preventing illegal mining. Where on this
shortage of minerals.
Transportation and shortage of minerals.
Yes.
The state government may by notification in official gazette make rules for preventing illegal mining, transportation and storage. We are all three. We are on illegal mining. I submitted to your lordship that any mining operation in the absence of any of the requirements under law, so that would tantamount to illegal mining, which also includes.
Kindly read section 23 slowly with us.
The state government, if may by notification in the official gazette, make rules for preventing illegal mining. Your lordship may stop here. Illegal mining. So any mining operation, my lord, in the absence of an environmental or forest clearance would be treated as illegal mining. So here, my lord, the rules have been framed in exercise of 23C. A set of rules, my lord, which is styled as, say, what is the rules? 23C, my lord, your lordship may now turn to 23.
Lovely DGA draws our attention to the text of section 23C of the Act.
Yes.
To in support of his contention that the power has been delegated, rule-making power has been delegated on the state government for preventing illegal mining, transportation, or storage of minerals. And in exercise of that power, a set of rules have been made called, they are called as, Mr. Acharya.
Yes, they are called as Orissa Minerals prevention of theft, smuggling, and illegal mining, and regulation of possession, storage, trading, and transportation rules 2007. I have
Which rule?
page 209.
Give the copy of the rule. Good for that one. Modeling, illegal mining, trying to regulate possession, storage, trading, transportation of.
Yes, very comprehensive, covers everything.
Let us
So
examine.
here, my lord, yes. Lord, your lordship, look at that order. That is not the impugned order, by the way, but your lordship may kindly have the look at that order. What does the deputy director say?
Yeah.
Deputy director, my lord, says.
Page 169.
Yes.
Where is theft? Where is illegal mining? Where is illegal transportation? Not even a whisper is made in that order.
Validity of environmental clearance issued by the so-and-so in respect of your Thakurani block so-and-so expired on 31/3/2014. You are therefore requested to stop all kind of mining activities within your aforesaid ML area until further order.
Yeah.
This is the order, my lord. It doesn't.
But this order is not relatable to the provisions of section 22, 23B, and 23, or now you have to, those three sections is not applicable. Kindly now come to these provisions where you will show us.
23C, my lord.
23C,
mining operation.
power. It gives making power.
That is correct. So that
show the rules.
Rule, yes. Rule, my lord, for the purpose, your lordship may, mining operations are carried out to win the minerals. Any winning of mineral, even inside the leasehold area.
Correct.
In the absence of any of the requirements.
Correct.
Either EC or FC or consent to operate, is not permissible under law.
Correct.
So a authority, deputy director is the authority having the territorial jurisdiction in this particular DDM, whoever.
Read the objects and regions of these rules. Kindly see that. Kindly read the objects and regions, the preamble to the rule, the objects and regions.
Let me just clarify.
Yes.
It's a 2014 order.
Correct.
Read petition has been filed in the year 2024.
Yes.
After 10 years.
We'll come to that. That's a delay also.
Let me explain, my lord, one by one.
No, one by one you are treating this now.
14, my lord. No, I'll come to that. I'm not skipping. I have, my lord, this 14 order. In
So
the
we will
interface
take up now delay and latches. Or we will take up this.
No, delay, I'm explaining, my lord. Is how the estoppel.
Mr. Acharya, we will fully agree with you that there are many grounds available to you to urge. But we shall go methodically.
That's
now
correct.
You are on the rule page. Don't jump to another provision. That's not a good rule page. With due respect, I tell you. Kindly convince us how this impugned order is applicable. Because we are halfway through. We have turned the pages now.
No, your lordship may go through that.
We leave it now.
No.
Another ground now.
That is not my intention. Your lordship said that deputy director's order is to be first seen. What is that order?
That is.
Otherwise, there is no meaning to go to the rules.
Therefore, we
have to see the order, whether that is the order, impugned order or not.
Read.
Or your lordship is judging the validity of that order. or in the absence of any challenge for long 10 years, and without any ground to that effect, even in the petition, your Lordship would take me to argue on that, because I have not given any reply on that also. Neither there is any pleading, nor there is any reply. So how do I argue on that?
No.
On my own, this is an order of 2014. Several petitions have been filed by the petitioner at different forums, including the Supreme Court. Before this Honorable Court, this 14 order, my Lord, has never been challenged.
Mr. G, we are on a particular point of law.
That's correct.
You complete it and then jump to another point. We'll consider. Not going like that. We will not agree with that. You are arguing that this notification is issued under particular sections of the Act, and particular section gives the power to make the rules. Under those rules, this has been issued. We are taking that aspect. Let us not go to deviate from that.
No,
you are entitled to say this question may not arise because there are no pleadings to that. If you say and leave it, we will write that way only. But we now we are asking you.
No, therefore I have to answer a particular thing which has been pleaded and argued in the petition. I can't, my Lord, I am not expected to answer certain questions, my Lord, which is not there in the pleading by either of the parties.
No,
how can I go to, my Lord, to this, my Lord? This is not neither a decision of lease, nor it is, my Lord, in a way, my Lord, it is a lawful order passed by an authority, my Lord, who is enjoined under the statute to ensure that no mining operation is carried out, my Lord, illegally. I may, my Lord, say so, because the requirements under law, my Lord, it is the duty of the Deputy Director to ensure that mining operations are not carried out in violation of the statutory provisions. So that was exactly the scenario during for which Saha Commission was set up.
Taking us to
and 14 order is not under challenge. Your Lordship may record it.
Text of order dated 31/3/2014 at the 9 submits that the said order is not put in challenge
in any neither in this petition nor in any earlier proceeding also initiated. Yes. No, that is to be seen. In 10 years, so many petitions, 7 writ petitions have been filed.
And therefore,
not even before the Supreme Court, Your Lordship.
Examine the validity of this order, which apparently has been issued by a competent authority.
Correct.
Who a decade ago?
A decade ago, that too entrusted with the power to prevent illegal mining.
That you have to settle. That you have to show us. We are not convinced yet. That last sentence. That you have to show us.
Yes. The Orissa minerals. Then I am asking myself, who else?
We do not. Administrative law. Any standard book.
No, that's correct. But who else?
That question is not left to the
and that to the very same Deputy Director has permitted them also to carry on the operation. So that order 21 who has committed. If this goes, my Lord, his earlier 21 order also goes. He is the Deputy Director.
Mr. A.G.
So that
we have been taught in administrative law.
No, my Lord, I am showing the order.
Is not who else.
Lord, he can't sit on it. Lord, he can't sit on the branch of a tree and cut at the road. Your Lordship may look at the order, initial order of the Deputy Director, by which he has been permitted to carry on. That is the order of the Deputy. Then he doesn't have the authority also to allow him to carry on the operation.
But that is not before us.
So then, so this is also not before Your Lordship. Neither that, no. Milord, how can, where is it? Milord, let me just ask, where is that pleading?
Is it
that the Deputy Director lacks the jurisdiction and authority to pass such an order? Where is that pleading? Let him show one sentence, then Milord, I'll bow down and I will stop
down now.
Your Lordship is writing down, it is not in the pleading.
That is what we have written.
That's correct.
No, if you say, Mr. A.G., we are not here to quarrel with you. We are here to decide the matter in accordance with law.
No, that is true.
I'm asking you, and you have to be little fair to the court.
I am more than fair. I am not submitting anything which is not, Milord, every order, your lordship, every,
so that deputy directors are by which it is there, it is an issue.
Our interaction should generate light. Our interaction should generate light.
Of course, Milord. I am on that. That is correct.
If it is generated, we will take that also. That is another thing.
No,
that is light is expected to be generated, not heat.
No, not Milord. I am not
supposed to
contributing.
Because you are the constitutional authority.
No, I am,
Therefore,
Milord.
we request you, be gentle to us.
No, I am
Fair to
always
the
gentle,
court.
Milord. I am always, Milord, have I been
Otherwise, we
unfair?
will treat the matter.
No, Milord, have I been unfair?
No.
In which
No,
way?
we
I
are
am
requesting
unfair?
you.
No, I have not been unfair. I am
no,
just
we'll not
showing the
say that.
provisions one by one. And that too, Milord, your lordship, I am also expected to be put, Milord, your lordship should put me a question which is required to be answered by you. I am not, Milord.
Kindly come to ground 3, K of petition.
Exactly. Specific.
Kindly come to ground K of petition.
Page 24.
The submission.
Where is, Milord, that lack of jurisdiction? K is not
wrongly.
No.
See, that
No, Milord, was wrongly issued by the on erroneous grounds.
Yes.
Leading to, Milord, it is not the ground he says he lacks environmental clearance. It is not a ground that he lacks jurisdiction.
The submission of Mr. E.G. is that there is no challenge to the order of the deputy director is absolutely wrong because such a contention is specifically taken at the ground K of the writ petition, although not on the ground of competence.
That's correct. Next, that is because your lordship is putting me a question whether he is authorized to issue a letter that please don't carry on because you lack a statutory clearance.
Can you make
this is neither a rescission of the ledge.
Can you make our dictation better than what we have?
No, Milord, I am not. I am submitting. It is not, Milord, the.
We said that.
So therefore, Milord,
where a document on the basis of which infraction of rights of the citizens have happened, comma, it is open to the writ court to examine entire record, including validity of such instruments, which necessarily will lead us to examine the competence as well.
No, that I am not
for this view from the apex court decision in.
Milord, I am not disputing your lordship's power. Your lordship is taking me to a different arena altogether.
No, we are answering.
I am not. That's correct.
Mr. E.G., we are putting your argument.
Let me
argument.
No, your lordship is as if, Milord, I am sorry. Maybe there is at some point I am missing. Your lordship may kindly appreciate my approach.
Definitely.
I am not on the question of your lordship's power to examine the correctness of a document in a writ proceeding. Did I submit so?
No.
I am, Milord, putting my endeavor to show to your lordship that a lawful authority, deputy director, is a designated authority under the Mining Act. And it is his bounden duty to ensure that no mining operation is carried out in infraction of a statutory requirement. That is my argument. Submission.
Repeats that the deputy director has got
is not powerless.
Competence, and that he is not powerless to issue order of the kind.
That is exactly what he said, that you don't have the forest clearance. Please don't carry on the mining operation. The moment he produces, so he may, so therefore, the question of it is not, it doesn't tantamount to neither termination, nor rescission, nor the a grant of the lease, etc. I am conscious of that. So, then what for the deputy director is sitting there? He is a designated authority. No, Your Lordship need to know also this aspect that he is a authority statutory.
What for he is sitting there, that question may not be put to the court. It's not.
No, let me, Your Lordship, while deciding a case also, the ground reality is also to be taken into, because this is a national resource.
Yes.
So, Your Lordship knows the past also. Many such, and this particular, not only a large number of lessees were put to 4 years, 5 years, not only this particular lessee. There are several lessees, including 2 of the judgments which I will cite before Your Lordship. R.P. Saab was before this court, which went up to Supreme Court also. Similar such, stoppage of mining operation occurred in common cause case also. So therefore, the deputy director, says that you kindly produce, it has already expired. The statutory document is submitted before him. It is the authority who is to permit, grant the trading license, grant the transportation, etc.
Yes.
So, Your Lordship, what for this rule has been framed?
Can we see the rules now?
Yes. Your Lordship may come to that.
Yes.
The Orissa minerals, etc., prevention of theft. That the very word, Your Lordship, prevention of theft,
smuggling,
and illegal mining.
Yes.
So illegal mining is what that has not only been below in common cause, exhaustively deals with that. What is illegal mining? We'll come to that. And regulation of possession, storage, trading, and transportation rules 2007.
Yes.
Your Lordship may kindly come to who is the competent authority.
Yes.
B, means officers as mentioned in Schedule 1 appended to these rules. That's it, may kindly come to Schedule 1 now. Schedule 1. Schedule 1, Millard, at page 248.
Schedule
1.
What is? Which is this is deputy director of which area?
The deputy director.
Go to the annexer.
Kyunjar.
Where is that officer? Sure. Choda is there, Koira is there, Rourkela is there, Jajpur Road is there, Talcher is there, Sambalpur is there, Koraput is there.
Mining officers.
No, he is not mining officer.
No, there must be a notification. Maybe it's in 2007.
Sure.
So, no, I have to produce. It is the book which was published in 2000. I think that must have been. I have to see. It must have been a new subdivision, new division.
This is as on.
Maybe Milord in 2012 might have been created. So maybe when this 2000. No, I can produce that. So it must have been earlier under Joda. Subsequently, maybe Kyunjar might have been. I have to
verify.
Milord.
Drew our attention to the Schedule 1 of 2007 rules to contend that the author of the order dated 31/3/2014 at Annexure 9 has power to issue that order.
That Joda was earlier under Champua subdivision of so and so, Koira to Sundargarh. But I have to show that it was earlier mining officer Keonjhar.
We have very carefully read and reread the item numbers 2 to 8 in the schedule, which specifically mentions the deputy directors of specified areas and the author of the order dated 31/3/2014 is not one of them. Now the AG submits.
No, that is Joda Circle. It's not. I'm sorry. Keonjhar, I was reading. Joda Circle, Keonjhar. Joda is there. I'm sorry.
That is
it is
Joda.
there. I'm sorry, Miller. I was thinking Joda is in Keonjhar. No. District Keonjhar. Joda is there. Item number 2, Miller. Deputy Director, Mines, Joda. Then it is Keonjhar District. I'm sorry.
Kindly come. Not be sorry. Kindly go to next point. Next item. In respect of Keonjhar, the power is given to mining officer.
No, all minerals except precious and semi-deputy director mines, Champua subdivision of Keonjhar district. It is there, Namila, jurisdiction. Right, there is no. No, Milord. Your Lordship meant 2. Deputy Director of Mines, Joda, Champua subdivision of Keonjhar district. All minerals, so and so. Mining officer, Keonjhar, all other subdivision of Keonjhar district excepting Champua subdivision. Champua is covered by Joda. That's got it, Milord. 2 covers Champua subdivision. So mining officer Keonjhar in respect of other subdivisions. Joda to likha hai.
No, I thought it's changed. No. Kindly come to the description under the signature and name of the officer.
Deputy Director Mines, Joda Circle, District Keonjhar.
District Keonjhar.
Yes.
Joda is not Joda. It's not Joda Circle which is mentioned in the schedule. It is district.
No, Joda is not a district.
Joda is a district.
Joda is a
subdivision.
Joda is a place. Not even Champua is the subdivision. Joda is not a subdivision.
Joda is a place.
The office is located at Joda. Headquarter of the Deputy Director.
Yes.
Mines, Joda is located at Joda. Jurisdiction is Champua subdivision. This particular Lease, Milord, comes within the Champua subdivision. Champua.
Kindly read 9. Item 9 in the schedule.
Mining officer Keonjhar, all other subdivision of Keonjhar district excepting Champua, because Champua is covered under Joda, excepting Champua.
Subdivision is Keonjhar.
No, Keonjhar is not Keonjhar.
Subdivision of Keonjhar district.
Champua is
Champua subdivision.
Champua is a subdivision.
Which covers the Joda Circle.
Joda Circle.
Is it true?
TDM Joda, his jurisdiction is Champua subdivision. Mining officer Keonjhar, all other subdivisions of Keonjhar district except Champua.
Last sentence. Mr. AG tells us that the Joda circle mentioned in Annexure 9 order comes in district Keonjhar of Joda circle. Correct?
Yes.
Joda circle.
Milord, sorry, I couldn't catch.
And therefore, the order is competently passed.
He is the competent authority. DDM, Deputy Director, Mines Joda.
And therefore, the Deputy Director is the competent authority.
It's not needed. Now it's already covered Champua.
Now, let us see how.
So therefore, the Deputy Director is the competent authority
for actions under these rules.
Under
whether the action in question falls within the rules.
No,
that
that's correct. Your Lordship is absolutely correct.
Yeah.
So now your Lordship have to see whether what is illegal mining. So that is not only from this, your Lordship may for the time I may request.
Common cause, Apex Court said common cause.
Yes.
What all is required, if that is not required in mining is done, it is illegal mining.
Correct.
But whether that idea you have adopted in these rules. In these rules,
my lord,
where rules are not there, Apex Court said, whatever certificate A, B, C, D, etc., without them, if you do mining, then it is illegal mining.
Correct.
That is not, that was in the absence of the rules relating to illegal mining.
That's correct. No,
That's
rule is
common.
there, Miller. No, rule mining, MC rule 1960, your Lordship may kindly see. That is illegal mining has also been defined. Beyond that, also the Honorable Apex Court has gone. Miller, MC rule 1960.
No, we'll go there. No problem. We'll go there.
Yeah,
whether
your Lordship
will come,
Miller,
will come.
I will
Just
go as per your Lordship's query. I am not going in my own way. Let me be very clear.
No, you go in your way.
No, so therefore,
you will go in your way.
A question, I am bound to answer. Not that I am trying to evade.
No,
but I am
that.
Yes. So therefore, your Lordship, there is no question of any heat argument confronting or so the question, my lord, very limited thing which my lord revolves. Let us come back. So the question of extension of any lease period, whether it is permissible under law. That is the number one thing.
Extension. Is it in respect of
beyond 31/8/21 is the issue?
No.
So now your Lordship is dealing with a scenario whether any period can be granted beyond the last renewal period.
It is in respect of 15 million capacity, metric ton capacity, or 4 million capacity, in respect of which it is. For the required permission which Annexure 9 is mentioning, that the mining area, so the validity of environmental clearance order.
That is not the issue, Milord, whether it may be XYZ quantity is not the issue.
It's a wholesale.
Issue, yes. The question is, that's correct. All pervasive means, Milord, it is for the period 21, but whether it is permissible.
That is giving clearance.
Yes.
For
initially
4 million,
then 15.
4 million. Kindly is ground K. Kindly come to 10K. Ground 10K.
10K.
Page 24, rock bottom.
Which sentence you are?
Page 10.
Page
10.
10. Yes, my lord, please.
Kindly read K. This is what they are saying. We are only putting it to you. Petitioner 1 had a valid and subsisting 2004 EC for 20 years.
That your lordship is referring to annexure 8. 8.
Annexure?
8.
What's annexure 8? Annexure no. Annexure 8.
It's not.
That
is the thing.
Yes.
Expect.
It was valid till 13/8/2021.
Right.
Yes.
Intercom. That's correct. That's correct.
Now, why your officer says you have no clearance at all?
2004, it was granted earlier. Then they wanted an enhancement, increase of the quantity.
Yes.
So that order
That he
is
could have said.
My lord?
That he could have said, arguably. But when the clearance is up to 31/8/2021, how could he say you shall not function in the mining area at all?
No, that's correct. No, Millard, that is annexure 8, na, that is what. Millard, annexure 8, your lordship may kindly tell.
Yes.
Lordship got it, Millard?
Yes.
Expansion of Thakurani so. Environmental clearance regarding.
Yes. Where is that which says for 20 years it is valid? Yes, document.
Yes, Millard.
This is not the document.
That is Millard annexure 7, your lordship would find.
Kindly indicate only the annexure and page number.
Yes, annexure 7.
Yes.
Page 139.
Yes. Come to 139
at 140.
Kindly take your seat.
That is not legible. So therefore, a legible copy, your lordship may refer to 145. Page.
145. This is legible to us anyway. We'll read 145 also.
At 147.
The same thing has been Millard, a typed copy has been given.
Very no issue. Generally, we do not read per typed copy because some typographers may do mistake.
That's
therefore original letters we read. 148. 147. On the clearance for 20 years and flesh clearance will be required at the time of renewal of lease. First condition. And that paragraph AI. years.
Yes. So then your lordship may.
Yes.
Your 20 years, that has been clarified in two documents. Your lordship may now come to.
Yes.
Annexure 8 million. This is 29th October 2008.
Yes.
Your lordship may turn to page 161.
161.
Yes. Specific conditions. Lordship got it.
Yes.
Roman 3. Environmental clearance is valid up to 2013-14.
Sir, please read to.
Environmental clearance is subject to grant of forestry clearance. Yes. That is FC. Environmental clearance is valid up to 2013-14.
Yes.
Working of the mine beyond 2014 based on the established reserve shall be commenced after prior clearance from the Minister of Environment and Forest. So therefore, relying upon this 2008, the Deputy Director says, it is over. 31,340.
No, that is for other quantity. Kindly see 150.
No, sir, it is not in this lot. It's a combined quantity now for enhancement. It was 4. Now, so therefore, there is no separate, it is 4, then it is 15. Not like that. It's a quantity. It was, suppose earlier it was 1 million, then 4, then 15, like this. So, judging on that, so this revised clearance has been given. It merges with that. So we can say that it was valid. So therefore in 15 they clarify. It is coterminous, but because all mining operations were stopped by the Supreme Court order, Milan. Also, in addition to that,
Kindly come to the subject of that document. 29 October, that annexure.
Expansion of Thakurani or Chevali, Balta and Thakurani.
This was for expansion. Not for that original clearance at all.
Let me read it then.
It does not rescind the original clearance at all.
This is also expansion. The other one also Millard expansion. 2004 is also expansion.
That has been granted.
Yes.
Now
that is for 4.
Correct.
This is also expansion.
This does not invalidate it does not cut short the period granted under Annexure 7. Simple. This Annexure 8 does not subsume Annexure 7.
Your Lordship meant to say that it was for 4 MTPA.
Even assuming that way, Mr. Acharya.
That is, your Lordship is correct. But the question is, all these things become academic now. What I mean to say. Those things, my lord, only are the purpose of academic discussion. My lord, I am explaining. That's what. Now, my lord, the whole thing would depend upon the statutory limitation. Can it be granted against law? That is the thing. Your Lordship may be correct. For academic purpose, these are may sound very alluring. But the question is, there are 2 issues. Your Lordship may keep that in mind. In 2014, when this order was passed, not that the common cause was going on, Supreme Court was in session over the matter. All mining operations across the country, not only in Orissa, were stopped. So therefore, my lord, Supreme Court came very heavily. A commission was appointed, Justice Saha, penalties were levied, etc., for violation of forest and etc. due to want of statutory clearances. So, my lord, apart from the definition, my lord, contained in Rule 2 of the MC Rules 1960, what is illegal mining? The Supreme Court also expanded its scope. When to say that
without that certificate, if you do, it is illegal.
It is illegal.
Correct.
So the question is now, they could have written that we have got 4 MTPA. Why do stop us? They didn't do. They said that we had the clearance, then 15 million. The government of India clarifies it. Your Lordship may kindly, it was co-terminus, but subject to Supreme Court's permission. They went to Supreme Court in 2019. Supreme Court also similar in the IA. I was pointing out the other day. I should not repeat it again. So Supreme Court says that for the remainder, you grant. Remainder he has operated up to 13th August 2021. Now the question before you is, my lord, squarely revolves around 8A6. Whether the court can at this juncture consider all these aspects and grant an extension, whatever in the nature of either permitting the leased operation to be carried out beyond that statutorily prescribed period at this juncture. This was the question, not for the first time. It is being agitated in this case. There are 2 such cases by two coordinate benches of this court also. I was R.P. Sao and JDL Mines. So I am showing these 2 judgments your Lordship may consider. Since, my lord, there are 2 earlier judgments on the very same point, very same issue, very same issue also.
You are right. We have one question.
Yes.
Where is the extension he is seeking?
Extension?
Where is the extension he is seeking? He is saying, I have been granted 20-year period. A particular period is cut short by the illegal action of the mining, the manager, the deputy director. You add that period and give me 20 years. Where is the extension? Extension is he is allowed to work the mine for a period of 20 years. Then there is a provision for extension through another 10 years. In that connection, he has lost the legal battles. Now it is on the floor of the highest.
No, Milord, that is exactly the same thing.
Where is he seeking extension?
No, Milord, that is the same argument. Was your Lordship may have a glance at these 2 judgments.
Yes.
These are there are already 2 decided cases on the issue, the very same issue. Your Lordship may disagree with that in which way I can, but there are. It's my duty also to bring your Lordship's notice to earlier.
We appreciate that you are doing your duty more than what others would have done. We appreciate that.
No, it is not like that. It is everybody, the duty of every. Yes,
we appreciate.
I am not doing more than what is required. It's an humble duty of me to point out law. Milord, in the absence of also a proper assistance to the court. Your Lordship is, I think, misunderstanding me at some point. And I want to. So it's my duty. It's a question when it comes to state's interest. It is my duty, Milord. I am doing my duty. It's not anything beyond what law I am doing. So, Milord, had there not been the very same point, I was also arguing and Milord became unsuccessful.
I suffered the order there.
That's correct. So, therefore, not that. So, it is my duty to.
No, we appreciate that Advocate General is
judgments
out of interest in the matter. We appreciate that.
So, 2 judgments, Milord, I have given in the counter affidavit itself. Milord, one is RP, your Lordship may come to, and another judgment of also Karnataka High Court. No, common cause will go later. Milord, illegal mining, I think your Lordship should not have any doubts now.
No, no doubt at all. Where there is no certificate, if they do illegal mining, it becomes illegal. Whether rules define or not.
That's correct.
We agree.
So that's a law declared under 141. So common cause case. So therefore, Milord, I am not into. So this very same issue, Milord. It is 6. I'll go to that. Milord, this your Lordship may first see this. Yes, in 2016, Milord, this was again in common cause 2, Milord. Judgment nature.
We agree with that. We fully agree with that. It's a well-established principle.
Yes. No, 8A6. Now I am on 8A6, Milord. 8A6.
886.
Interpretation of 886.
Yes.
But if he succeeds here, he has a good case. If he overcomes this statutory bar hurdle, whether it can go beyond the last renewal period, then he may have a good case. To that
No, we are
extent,
not convinced of that also. We are not there.
So
we
this
have to
will
examine that aspect.
Yes.
We don't immediately
There is a
jump
serious
to
dispute.
a conclusion in his favor either.
Hey, they would have been directly to her.
Thank you. Thank you.
Yes, of course. Take a phone pen. That is there now already. Why should you show this again? Unnecessarily burden.
Yes, sir.
Lord, your Lordship may only the conclusion portion, your Lordship may look at para.
We have no confusion at all.
Yes.
Unless you generate one. Just read that section.
Your Lordship, these two judgments may be profitable.
Yes.
Page 43 starts with Milord R.P. Saab.
Well,
this force measure has also been dealt with, Milord.
yeah. One is by Chief Justice.
Both are by Chief Justices.
Both.
Justice Javeri and other is Justice Chakradhari Saran.
With Justice Didas.
And another judgment is of Justice Murlidhar.
Yeah.
The other one we have given, I was showing. It is there, huh? Temporary say Jindal case. Another by the very same Sarda by Chief Justice Murlidhar. Three judgments. The scope of 886.
Yes. We have got. Now, which paragraph you want us to?
Milord, para 2, your Lordship may look at the factual background. The petitioner, who is the lessee in respect of Guwali iron ore mines, situated over an area of hectares in Guwali, Panduliposi, Topadihi, Loipada, and Rugudihi, and Sidhamatha Reserve Forest under Barbil Tahsil in Champua subdivision of Keojar. Milord, the very same Champua is the has filed the present writ petition seeking restoration of the lost period from 27/6/13 to 16/5/14, that is 10 months and 20 days, and from 23/5/15 to 10/4/2018, 34 months and 19 days. Thus, total period of 45 months and 9 days, for which the lessee could not operate its mines due to interruptions, disruptions, cost which was beyond the control of the lessee, more particularly when such disruptions were caused mainly by the act or omission on the part of the authorities of the state government. He further submitted that various legal proceedings are pending before this court and the Honorable Supreme Court in respect of the mines in question. The substratum of the challenge of the petitioner in this writ petition is the decision dated 22/10/19 of the state government, communicated to the petitioner under Annexure 30 to allocate the mining lease in question in favor of Odisha Minerals so and so. It was given to OMC after expiry of the period. For ready reference, relevant portion, Annexure 30 is quoted below. Discussion on Guwali, government has decided to allocate above mining lease in favor of Odisha Mineral Exploration Corporation, which is lapsing.
Can you come to 4.1? That covers the issue. Exactly, it hits the whole side. Paragraph 4.1.
Since there is no approval as yet from the central government.
Yes. That was the
issuance of runs contrary to the above provision of MMDR Act. Not which one? The reservation of which is reproduced below.
That was a case lacking approval.
The department regarding extension of lease period. Yes, amount of stamp duty. But these are not relevant. Support of his contentions, etc., etc.
That was a case that lacked approval. That was the jugular vein of that decision. And that was a case of cancellation of a lease.
No, not cancellation.
Kindly
He was
come to
not
para 14.
31/3/20, my lord. That
Kindly
was
come
the
to
natural
para-
lapsing period.
Kindly come to para 14. It is a case of cancellation of lease.
No, Lord, he was having that thing. Your Lordship, in view of your Lordship, may kindly see. Lord, he relies upon that.
Correct.
Para 14, my lord. Your Lordship is referring to para 14.
Court makes the difference between extension of the lease and working of a lease. Para 14 is structured on the premise of difference being extension of the lease and working of a lease.
No, Lord, I am just reading that. But in the instant case, it was not cancellation of lease, but non-extension of the lease.
Non-extension.
Yes. So now, my lord, necessarily it amounts to extension.
No, that's difficult to agree with that. That is before the Supreme Court. The extension he had sought for, that you rejected, and the coordinate benches upheld your contention. Matter is in the floor of being debated on the floor of the apex court. We are not on extension. We are not on extension. We are giving our peace of mind to you so that you can convince us to the contrary. Otherwise, if we say, mum, and go to the chamber and write a judgment, that will not be hearing at all. It will not satisfy anybody. We are giving a piece of our mind to you that it is like this, etc. And that presumptions and conjectures may not be drawn by anybody. Nobody should draw the conjectures from our interaction.
No, what is I couldn't get it. That it's a discussion on the question of interpretation
That's what.
Relevant. That goes on in a courtroom debate, my lord. Nowadays, people think that media people sitting at the back, they think this,
we are not bothered.
Think they just said this. So it's not a thing. It has to, my lord, in every. This is a matter which may also decide the fate of other similarly circumstanced leases.
It will have
so that is why. That's correct. So we have to decide taking all practical aspects and the law occupying the field.
No, we made it clear because sometimes what happens, Mr. Acharya?
My lord. But I am a very open person.
Very open
I don't have any prejudice for any question.
Not as open
if a
as you
person
are.
deserves justice, my lord, I mean, I have considered in many cases very openly and fairly. In Supreme Court and this court.
We appreciate
so it's not a question of forcing my ideas on the court or to take a different view. So there are, my lord, a very clear mandate of law on certain aspects.
Correct.
And this law is also, my lord, your lordship knows, it's too elastic. Law can,
Very elastic.
it is never static.
Ultimately, what
it can be
just
that
say.
correct. So therefore, my lord, the interpretation aspect, it can stretch either way. So I am not on that. So I am conscious of the...
No, Mr. Acharya, we are telling you, we are giving a piece of our mind to you so that you will be in a position to clear the doubts that arise in the background. It is not that we are, therefore, on that basis, we are requesting others not to draw the conjectures and not to write anything
Another
on the basis
aspect-
of conjectures to us.
Another
That also we are
aspect, let me be very clear, your lordship, the present stand of the present government is ease of doing business. Milord, fundamentally, we are not opposed to any person who is coming to the state and investing a very substantial amount. Industries are also to flourish.
But
we are not
come forward if these things are allowed.
No, that's correct.
Nobody will come forward.
No, that is correct, Milord. So I have also been, Milord, advising the government in sensitive matters. Don't discourage people. If you are going to Bombay, Singapore, Gujarat, to no, you are
kindly see. Since you are saying
that is not Milord, my government, let me very clear on this aspect. It's a government, the present government is not hostile to the industries. Rather, we are inviting them, come, we'll provide. Unless you give them any captive source. Now, some sensitive issues going on in that Sijimali area. So every day, Milord, hundreds of POSCO went out. From Mithal, they went out. Ruyas, they went out. So we don't believe in the concept of signing MAUs, inviting them to you come here, and after a few years take a bad experience from the state and go back. That's not the intention. We have to also be, Milord, very positive in a sense that industries would also flourish. It's a very pragmatic idea. I have also been doing that. In many issues, if the land issues are there, I'm calling the officers, resolve it. Don't make them run after you. Your Lordship may ask in many areas. So therefore, fundamentally, ultimately, Milord, I have to see whether it really goes to the benefit of the public or not. Natural resource, Milord, even in many cases, we put it to auction. Many auction purchasers are not performing. After till 2 years, Milord, now we are lapsing those leases and giving it to some PSU or etc. is in a stalemate condition. That is, revenue is also, Milord, had drastically gone down in the last 4 quarters. So therefore, Milord, I am conscious of the ground situation also. On sheer technicalities, there should not be any impediment for any person whatsoever in whose favor a legal right has been created to go on. So, Milord, I will come back with these 2 judgments. So maybe some other day, if your Lordship would keep it. Or
the fact
Gopalji, I have not slept for 2 nights. Since Sunday I traveled. It is daily. Last night took a morning 5 a.m. flight.
Let's bring it to closure, but there's still court.
I was not since I had committed, I did not want to take an adjournment today. I was feeling sleepy also.
There is only one advocate general.
Yes.
We have so many courts. And here cases.
So today I have already done 2 cases. Despite my dizziness, I attended 2 cases virtually in Supreme Court.
And request, we cannot say no.
Let it come a short date. I'm not asking for a long.
He will not ask for long date also. If you ask one, we will not give also. Therefore, kindly seek a short date.
Short date next week. Any date. Tomorrow, Vedant matter is there fixed before Hon'Ble CJ.
Monday you will come before we forget. There is Fali Nariman's famous book, Before the Memory Fades. That applies to the judges also.
Then let it be on 15th then.
15th?
Because I may go out next week. I'll be absent. 18, 19, I'm in Supreme Court. 15, Milord. 15. 15, I'm free.
Friday. We'll complete that. We'll keep other points on Friday.
Friday, 2 p.m.
Yeah. Complete that. And you also do not consume much time. We request you.
5 minutes.
Otherwise, we will not go on.
We will go on. 5 to 10 minutes by the watch.
And you also do not draw any conjectures. This is only discussion.
Deeply obliged. Can that block grants? That pension matter, there the other side is very insistent. In fact, let me be also very frank.
Ours is 15th at 2 p.m.
2 p.m. would be fine. First hour, let me finish.
10:30 we will have it day after tomorrow. 15th.
10:30, 2 p.m. It will be, I'll take hardly half an hour. I'll not.
You take your reasonable.
No, Milord, I'll not take.
Understand.
No, it is already covered. I don't want to stretch. 2 p.m. It will, because first half there may be matters also. That's the miscellaneous day. So 2 p.m. it will be ideal. I'll not take more than half an hour. Otherwise, I may file a written note.
Matter was heard at length again.
Miscellaneous day.
Learned Advocate General very fairly assuring us that you would not take more than 30 minutes from this side of the agreements. Right. Requests for a short accommodation. And learned senior advocate appearing for the petitioner side also agrees with that proposal. First, call this matter at 2 p.m. on 15/5/26.
Yeah. That is a pension matter, block grant teachers. So the other side is today it was, I think, posted.
It was at serial number 11.
So
we have passed the order already.
That's correct. No, I'm just reminding, for some reason, in a day, my lord, 2-3 heavy matters, it is becoming difficult to. So therefore, I may take accommodation.
Because it will come as it is. Matter is
directed for tomorrow.
No, because they have
posted already for tomorrow.
No, that's correct. Tomorrow, day after. No?
We have already
day after.
This matter is coming day after. On 15 matter is coming.
That matter is tomorrow.
That matter is posted tomorrow. We'll run time in that. Don't we understand?
Because yes, tomorrow there is another part. Vedant matter. It will continue. May continue for the whole day. I have to address it. So
day after tomorrow at 2 p.m. we request you to.
No. This one I will conclude.
That will give time. Mr. Mohanty mentioned that. Yes. Yeah.
Short. I will inform also.
My intent, no, Milord, we have intimated. Milord, what I am, Milord, in fact, we have set up a high-level committee. It may go in their favor. We are just calculating what would be it may come to 10-15,000 crore. That is how, Milord, 7 lakh employees was a block grant. So therefore, it's a very heavy. So therefore, we set up a committee. It may be more. You see, we have 7 lakh employees. So therefore, otherwise, my friend is also equally competent to do it. I have to.
No, in fact, I should appreciate
it's a pension matter.
All the lawyers we have put here, they are very good.
I have chosen because your lordship's court, I am concerned.
Really,
each one of them is. I have known.
They are doing.
There is no iota of doubt in me. Each one of them is very competent.
All right, we'll give it that matter. If that is the implication, that we cannot haste in that matters. We understand your difficulty also. That you have to handle so many things, advising the government. We all appreciate that. We really appreciate it.